Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3045, United States of America versus Larry Randall Brock, appellant. Mr. Burnham for the appellant, Mr. Hansberg for the appellee.
May it please the court, Charles Burnham on behalf of appellant Larry Randall Brock. Morning, Your Honors. There are two issues before the court in this appeal, both of which the court has seen before in prior cases in some form. The first issue is whether Mr. Brock's conviction for obstructing an official proceeding under Section 1512 is legally flawed, and there are several subparts to that. The second issue before the court is whether the district court erred by assessing a 3-level enhancement to Mr. Brock's sentencing guidelines for substantial interference with the administration of justice. And I'll address the issues in that order. The first issue in our brief for 1512 is the actus reus issue, which I won't spend much of my time arguing on. That's, at this point, something we're really just preserving. The court has ruled on that. The Fisher opinion stands, and we're preserving that for later proceedings. I'll just make one comment about the actus reus before moving on to the mens rea issue, which is that the government is correct that on appeal, we are not contesting that the evidence is sufficient to support the actus reus in this case under the definition of actus reus applied by the district court and by the Fisher majority. And the reason for that is important because it relates to the mens rea issue, that the actus reus of 1512, considered by itself, is really not inherently aggravating. In fact, some versions of the actus reus are praiseworthy. One of the ways to violate the statute
Are a bit what?
Are praiseworthy. Some versions of the 1512 actus reus are, I would say, praiseworthy. One of which is you can violate that statute by attempting to influence an official proceeding. It's almost rather unfortunate that we refer to the statute as obstructing an official proceeding, because really it could just as equally be called influencing an official proceeding. And I think that's important for the mens rea.
Not if you're using corrupt purpose or corrupt means to do so, which is what the statute covers. And the reason that the corruptly limitation is there is precisely so that the statute doesn't cover praiseworthy efforts to advocate or demonstrate.
I couldn't agree more, Your Honor. And that's why the corruptly issue is so important for this statute, because without, I would submit, a carefully thought out definition of corruptly, as Your Honor alluded to there, the actus reus, as other judges of this court have noted, has some very problematic aspects to it. And that's why we're, sorry.
Would you emphasize just on that point that Brock showed a genuine, not feigned concern over the presidential election? Why does that, and I take your argument to be that that would be a defense or that would vitiate corrupt purpose? How could that be?
But part of the way the corrupt purpose is sometimes formulated, this of course is not the formulation we're arguing for, but this is the way it's sometimes applied, is requiring consciousness of wrongfulness in addition to other aspects of it, right? That's the definition the government's argued for in the past. That's the definition the district court applied. And so the evidence, in terms of, if the question is the evidence sufficient to support the corruptness finding under that definition, that's why I get into that.
Let's say, I mean, I'm not sure that I'm following the distinction that you're trying to make. Let's say that someone has been in an election for a state judge, and the candidate thinks that she won, but she's not being recognized as the winner.
Mm-hmm.
And she sincerely and honestly thinks that. Does that privilege her to rally a mob to go and interfere with an investiture of the court, to break into the courthouse because she has a sincere belief that she's been wronged?
It certainly doesn't, the way, in just the terms Your Honor put it, doesn't entitle the judicial candidate to do that. But the question is, it's going to be different under every different factual scenario, but if the proof is there evidence that the individual in question, whether it be it a state judge or a protester, is acting wrongful? That's in addition to the requirement that the conduct be unlawful. Conduct can be unlawful without the defendant having consciousness of wrongfulness.
Well, in this case, Judge Bates relied on the corrupt purpose aspect. So let's set aside for now the corrupt means avenue that is sketched out in our prior precedent, especially in North, and just focus on the evidence of corrupt purpose. What is it about the evidence in this case? We're on sufficiency review, sufficiency of the evidence review. What is it about the evidence that we could deem insufficient to support Judge Bates's finding in the case?
There's two things. The first is that we have a finding from Judge Bates, and this is in the brief, saying that, let me back up for a second. The main evidence of intent that the government relied on in this case was social media, and that's in Judge Bates's decision. The government relies on that, and there's all sorts of stuff in the social media evidence. But importantly, the judge made a finding that not everything in the social media evidence is to be taken as a literal expression of Mr. Brock's intent on January 6th. And the district court, importantly, doesn't go through there and specify which Facebook post or email was particularly relied upon as being a genuine expression of the defendant's intent, as opposed to just culminating on social media, as the judge found. Some of the evidence was received in that light. That's the first problem. The second problem is, as we see it with sufficiency of the evidence, is this is again separating the question of whether Mr. Brock violated other statutes, misdemeanor statutes and such, from whether he had consciousness of an improper purpose on January 6th. And we contend that even on appellate review, the evidence all pointed in the direction of Mr. Brock thought he was acting righteously, patriotically, and with a eminently proper purpose. Now, of course, people can disagree with that. He was
Just say all evidence pointed towards that?
Oh, sure, Your Honor. Yes, Your Honor.
All evidence.
Yes, Your
So
Honor.
let's use methods on them like we used on Al-Qaeda. We'll get pardons for everything up to and including murder, walking around with flex cuffs. All that points to he didn't have consciousness of wrongdoing.
Well, that's why the finding is so important, that not all of the social media evidence.
Not all, but you just said all the evidence pointed in a way favorable to your client. But in fact, now I think where the district court was, that there's some mixed messages in the social media. And then there was his conduct on the day, which the district court also relied upon. And our standard review here is incredibly deferential. We would have to say that it was irrational, irrational for Judge Bates to look at that mix of evidence and conclude that there was consciousness of wrongdoing. So what in the record shows that it was irrational to look at these things, some pointed one way, some pointed another, and draw the conclusion that Judge Bates did?
I would agree with Your Honor if there was a finding from Judge Bates saying one of two things: either that all the social media evidence was to be taken as a literal expression of intent, or if the district court went through and said, these are to be taken literally, these are not. The district court did neither of.
A jury wouldn't do that. Why does the district court have to do that?
I think a jury would do that. They wouldn't be explicitly set out on the record because deliberations.
Maybe he did it in his head too.
I'm sorry?
Maybe Judge Bates did it in his head as well.
Well, I understand
We
that.
don't require the judge in a bench trial to spell everything out like an agency administrative record.
I understand that, but respectfully, if the judge if the judge had said nothing and just said, I find that the evidence taken as a whole, shows the proper intent, perhaps I'd have a bigger problem. But the judge took the explicit step to say, you know what, I'm not taking the social media evidence literally, as the government was urging the judge to do. The government relied very heavily on that, including things that I don't want to get into the facts more than is relevant in this appeal. But because the judge took that step.
Read the district, I'm just gonna make sure I'm clear here. You read the district court as saying, I don't believe any of the social media evidence. I'm discarding all of that.
No. I would never.
Okay.
That's exactly the point, Your Honor, I think, is the judge didn't then go on to say these 5 posts I think should be taken literally, and that's what I'm relying on. The judge didn't take that step, which doesn't leave this court with anything.
But we can look at the evidence we have to look at the evidence under sufficiency review and see whether it's sufficient. And because he didn't exclude any particular evidence, we would look at it as a reasonable fact finder and say, could this support, even bracket the social media evidence for the moment and think about the day. Is it your position that the actions that Mr. Brock took on the day, joining a mob, going to the Capitol, seeing law enforcement officers overwhelmed, barriers breached, windows broken, alarms blaring, a mob not following the guidance of uniformed law enforcement officers, that would be inadequate evidence for any reasonable fact finder to find an intent, a purpose to join this mob that was trying to stop the certification?
The answer is a reasonable fact finder could find that it was unlawful, which is why we're not appealing most of the convictions. I'm very much contend that a reasonable fact finder could not find that Lieutenant Colonel Brock intended to act wrongfully. That's the distinction I'm making between unlawfulness and wrongfulness. That's, I think, the critical factor here. All the evidence points in.
Yeah, I think the district court used the phrase, and in many cases do, consciousness of wrongdoing.
Yes, Your Honor.
So how are you defining wrongdoing?
Well, that's why I'm contending for a different legal standard entirely, because wrongdoing is not something that the courts have fleshed out, but the way it's
Well, that's
presented.
what I'm asking you. It sounds to me like you're arguing that he may have done things that were unlawful, but he wasn't engaged in wrongdoing.
Exactly.
Or are you giving that up? You're not arguing that. You have a different you're arguing for a different standard altogether.
Well, I have arguments in the alternative. One is this court should adopt the concurrence from Fisher, which is a different analysis. But two is even if the majority
The benefit one.
Yes, that's exactly right, Your Honor. But our argument.
Not making any, if consciousness of wrongdoing were to be sufficient to establish that he acted corruptly as a matter of law, if that were the case, then you lose.
I don't agree with that, Your Honor.
You said you have alternative arguments.
Yes, in the alternative, I would not concede that I lose, because wrongfulness.
For the benefit one, but the concurrence in Fisher found that the benefit test was satisfied in a very similar situation, in that Fisher and the defendants there, Lang and others, were acting to gain a benefit for former President, or I guess then President Trump.
Well, I part ways slightly with the concurrence, both in the abstract and as applied to this case. I see my time, I think.
That's okay.
Right? I think there's a number of problems with that. The one argument is that if benefits that are that ethereal can satisfy the test, the standard sort of collapses on itself, because every human action has some kind of a purpose. Secondly, if you look at the particular facts of this case and others, the benefit is not because we want Donald Trump to be happy. The benefit is for the country to expose what certain folks viewed as problems at the election, to do a public service, all sorts of public.
No, your client was quite clear. He wanted to have a new slate of electors put in, force members of Congress to sign it so that President Trump would remain president for a second term. That's what he wanted. That's what he thought was needed. That's what he thought was supposed to happen. So that was the benefit that he was seeking.
Well, the two.
And it would have been, a benefit to President Trump as well.
Well, there's two.
In his view.
I understand, Your Honor. And the two responses I would have is, one is the evidence showed Lieutenant Colonel Brock didn't consider it unlawful benefit. That's the way that test is phrased, is unlawful benefit. All the evidence
That
showed.
gets back to the difference between unlawfulness and wrongdoing.
That's right, but under the.
You weren't contesting the definition of wrongdoing, or you didn't have an alternative definition of wrongdoing.
Well, the cases don't offer a very good one. I contest.
You could offer it for your client.
It's in a moral sense, is the way I think it should be taken. Wrongfulness in a moral sense as distinct from wrongfulness in a legal sense. I think that's the only rational.
People who engage in civil disobedience are, the power of civil disobedience typically is, I know I'm violating the law and I'm ready to take the consequences for it because I'm responding to a higher law. And the higher law, in my view, is more important, and even to the point where I'm willing to sacrifice myself. But what follows from that is that the sacrifice is that the law does not bend and accommodate the person's individual moral principle. It applies neutrally to that person. And when the person acts in the face of what they know are legal constraints in response to the higher law, that the higher law is not factored in. Do you have a different view?
I agree entirely, Your Honor, and that's why trying to force the corruptly test into this situation is, I contend, not the best interpretation. A civil rights protester at a synod is breaking the law, but it defies language and history and our common understanding to say that person is corrupt. That makes no sense. And
The civil rights protester joined a mob and overwhelmed police officers and broke into a building to stop a person from being, seated because they felt I've been disenfranchised. I shouldn't have been disenfranchised. This, person should not become our leader. It would be the same analysis, wouldn't it?
I don't think so. This might be illegal, but I would say that we wouldn't say those folks are acting corrupt. Nothing dishonest there. There might not even be anything wrongful. They're breaking the law. That's the whole point of civil disobedience. But that's why I think it's so important that the wrongfulness and part of this analysis shouldn't be forgotten. That's why those protesters are guilty of disorderly conduct.
Sure. Where did you make all these arguments about mens rea below?
I'm sorry?
Where did you make all these arguments that you've been making here about mens rea in the district court?
Well, this comes to the waiver question, I think is what Your Honor is getting to. And absolutely, we can see that our closing arguments focused on the wrongfulness standard of mens rea as opposed to the unlawful benefits, simply because that's what I knew Judge Bates considered the correct test to be. That's what was fashionable.
Well, I mean, you've come here and said, I'm still making these arguments to preserve them for further review. So where in the district court did you say, Judge Bates, I understand that you think consciousness of wrongdoing is the test, but for purposes of preserving the right to review, I am also arguing for these standards that you've argued here?
I did not make that statement perfectly clear with Your Honor, but the 2 points I'd make in response is that at the motion for judgment of Rule 29, I made the motion, as I always do, to every element of every count, but then I went on to say, Your Honor, I'm just going to focus on what I think would be the most critical to the court. But the motion was made to every element of every count. Secondly, at that point, the Fisher decision.
Focus on mens rea at that point?
I'm sorry?
Did you focus on mens rea at that
Oh, yes, I
point?
did, Your Honor.
And you argued for?
I focused entirely on the wrongfulness standard because that's based on my strategy.
Alternative standard you argued for, other than the benefit, dishonesty and benefit standard, was a clear.
Didn't even argue for benefit below, you argued for wrong.
That's exactly right. And at that point,
But what was, I'm just asking, what was the standard that you proposed other than consciousness of wrongdoing that you thought Judge Bates should have applied?
I made my closing argument within that standard because I knew that what Judge Bates was going to do.
You said you made a motion. Did you?
I made a motion for judgment of acquittal.
So there isn't a different standard that you proffered for Judge Bates to assess the corrupt purpose?
That's absolutely correct.
Okay.
Even in your, just to clarify, because I thought you said you did a different argument in the judgment for acquittal. Is that not true? You did consciousness of wrongdoing both in your closing argument and in your 29 motion for judgment.
That's correct, Your Honor.
I'm interested in your position on the sentencing enhancement and whether the electoral count certification was a judicial or related proceeding that determines rights or obligations under the enhancement. And why is this not a proceeding that determines the obligations of the people of the country, the Congress, the candidates, and therefore within the definition?
Well, the definition I'm arguing for is that it was a judicial type proceeding as the C-free definition. And so the way I would come at Your Honor's question is every governmental function in some sense determines rights and obligations of Americans, because that's what government does. The statute here it would have been easier if the guideline. If the guideline had said judicial proceeding, which is my theory, that would make it easier. If the guideline had said governmental function, which is basically what I understand the government's theory to be, that would be easy as well. Instead, the guideline uses this term that I admit there's some ambiguity there. The government has some things I can say. I obviously have some arguments. So that's why I think the Seafried case is a good one, because it comes at it from several angles and say all the different kinds of analysis taken together tips the balance in favor of judicial proceeding being the way to harmonize that, which I would submit is in keeping with what the apparent purpose of the guideline.
Well, sir,
Right.
it's,
Well, let me ask you in that regard. Did you look at the legislative history of the Electoral Act in terms of what Congress intended in this regard?
I'm sorry, of the Electoral Count Act?
That set up this procedure?
I can't say I did, Is there a particular part of the legislative history?
Well, normally the standard is you look at the words, you look at the context, and you can look at the intent of the people who created it. And there is legislative history here that, at least in my view, does make it clear what was intended. Namely, it was debated on the floor of the House, and one view prevailed when the vote was taken. And why isn't that the end of the matter insofar as this court is concerned?
Well, I'm not sure exactly what Your Honor is referring to, but the way I...
Well, I'm referring specifically to the debate where Congressman Caldwell reported on the report of the special committee, and Congressman Dibble took a different view, and the committee's view prevailed. Why isn't that significant for determining what the act was intended to create, and therefore relevant to interpreting the guideline?
I confess I'm not familiar with the debate Your Honor is referring to, so I'm having difficulty.
Well, take it then as a hypothetical, and I can give you citations if you want. I'm just surprised nobody looked at that. I didn't see it in either brief.
Perhaps that's an oversight. I could readily believe that's an oversight on my part. I can't
Well,
address
I'm
it.
not trying to place blame, but I'm just saying as a matter of analysis, the Supreme Court instructs us how to look at these statutes and guidelines, and yet no one's brief talked about it, and neither did either of the district court opinions that are cited to us. And maybe there's some good reason for that, but I'm not aware of it. So you like one judge's view, but that judge cites a lot of things, but he doesn't talk about what the people who were voting on the statute intended. And the other district court reaches a different view, but also never refers to that. And it just struck me as odd. And do you know of anything that says that this court, in trying to figure out how the guideline should be interpreted, is not to look at that type of history? What did Congress intend to create in this procedure?
Is Your Honor referring to the sentencing guideline or to the Electoral Count Act? I think I'm
referring to the statute. And
the Electoral
the
Count
guideline was implementing the statute.
That's something I would have to address in a supplemental brief. It's not something I've looked at.
Any reason you didn't?
I don't think I came across it in my research that there was legislative history on whatever particular point Your Honor is referring to. Something I'll certainly look at.
So, Mr. Burnham, in the briefing, you characterize the Electoral certification proceeding as ceremonial. Is that important to your argument? In particular, do you dispute that the electoral count certification that Congress was engaging in would play a legally operative role in presidential succession?
I'm not sure exactly what the court means by legally operative, but it is relevant that the Electoral Count Act is largely ceremonial. The more something looks less like a judicial proceeding and more like a normal governmental function, and I agree, it's not 100% bright line, the more likely it is to come outside the ambit of the statute. And the Electoral Count Act is, as we've all learned in the past few years, is largely ceremonial. Usually it's just a matter of counting 1, 2, 3, 4, 5. There are specific instances, perhaps, in which there can be objections, and then there's some kind of deliberation that might arguably look like, getting into the nature of a deliberative process, but there's no witnesses, there's no parties. Even the scope of the decision that Congress is contemplated to make is so narrow.
It's very structured. I think that's right.
Yes.
It's structured by the Constitution and it's structured by the Electoral Count Act. But I'm not sure that cuts in your client's favor in the sense that, as you said, the guideline appears to apply to a judicial type proceeding, and the formality, the bringing of the certificates, the passing on their legitimacy, the raising of objections, and then the verdict on them, the certification on them, arguably is more judicial-like than anything else, or almost anything else that the Congress does. And so I guess the question is, why doesn't that put it within the guideline rather than outside?
Because we have to look at what happens after there's an objection. An objection, yes, it kind of sounds like something you would do in a judicial proceeding, but what happens after that? There's no judges, there's no procedure that I'm aware of for swearing in witnesses. It's not like an impeachment, for example.
Well, all of this was debated. That's why I can't understand why no one looked at this legislative history for the statute. They drew analogies where members could raise questions about the certifications that were presented to it and get answers, presumably, from representatives from the state or their colleagues from that state. I mean, this is openly debated. It's not hidden. It's in the congressional record. Anyone can read it. And so that's why I'm just wondering if Congress contemplated this was going to be more in the nature of a judicial proceeding. And there's nothing to suggest that the guideline was implemented ignoring that congressional intent. Why isn't that significant? Why isn't that significant as a matter of analysis of trying to figure out how to look at this proceeding?
Your Honor, in answering that, I would draw a distinction between the guideline, which I admit is ambiguous, and so Your Honor's point is well taken, that there might be some legislative history there that would be very helpful. I would submit the same is not true of the Electoral Count Act. The Electoral Count Act is much more clear to my mind than the guideline. Neither party is.
Yes, but you didn't look at, you acknowledge you didn't look at the debate.
I do, I acknowledge that, Your Honor. The point I'm trying to make is the legislative history becomes more critical if you have an ambiguity, is the normal procedure, right? If the text is
I think the district court opinions that both parties cite suggest that there are two ways to look at this whole procedure and what's involved.
Just looking at the text of the Electoral Count Act, under Section 5 of that act, the states are given an opportunity to resolve controversies over the election before January 6th, and they can do that under judicial or other methods or procedures. And if there were a court case in a state that was trying to resolve some challenges to their electoral slate, would obstruction of that court case in your view, fall under the administration of justice guideline?
Your Honor uses the term court case. Obstruction of a court case certainly would. There's no
That's what I'm
question.
asking, and you say
Oh,
it
sure.
would.
Oh, sure, yes.
If,
certainly.
if the state had chosen to resolve a conflict over that through a court case.
Oh, sure,
that-
certainly,
that
yes.
would. So for you, the hard line is court case and not court case.
Basically, there might be some ambiguous cases because judicial type proceeding, perhaps you could have an administrative proceeding with an administrative law judge. Maybe that's an edge case or something. But a court case, I think, is clear. It would apply to a court case. There's no question in my mind. And so the way I would frame the analysis is how similar and how different to a court case is the proceedings pursuant to the Electoral Count Act. So
That's helpful. And if it were a voting rights case in a court, Section 2 case or something like that, in your view, an effort to obstruct that, to interfere with the claims of voters that their votes were not given weight, that would also, obstruction of such a judicial proceeding would
yes,
be under the administration of justice.
no question about it, Your Honor. And I think that becomes clear if we go past the objection provisions in the Electoral Count and look at what happens next. The universe of issues to be decided is so narrow and the procedures are so unlike judicial proceedings that it would be error to conclude that the Electoral College in any way resembles a judicial proceeding because they're really not supposed to be, according to most people's views, debating the election the way a court would. They're limited to saying,
Courts, you just spend more time in the district court. If somebody came before one of our trial judges on a summary judgment argument,
Mhm.
and the question was, is this evidence sufficient? The analysis is not that different from the analysis at the electoral count certification proceeding, right? Is this evidence sufficient? Does it add up to support for this candidate or that candidate?
well, I would look at it like this. The range of decisions that a district judge has to make is so vast and compared to the Electoral College that the two are not comparable. The Electoral College, basically the decision they have to make is this piece of paper the right one or this piece of paper? That's it, really. That all they can do under the Electoral Count Act, which is not different than what government agencies do all over the government,
Isn't
which
it the difference that in a court case, you're adjudicating individual rights and applying the law to them?
Mhm.
And no one was adjudicating individual rights in the electoral count, correct?
I agree with that completely.
So they're not applying law to determine individual rights, nor is the force of the state, the force of law applied to the outcome. We just, the goal is that people accept the electoral count certification by Congress, but Congress doesn't send troops out to enforce its decision.
That's absolutely
Doesn't
right.
send marshals out to enforce its decision. Is electoral count act one of the statutes that this administration of justice guideline even applies to?
No, I don't think
It's
so.
not a relevant statute for purposes of the administration of justice guideline.
No, I don't think there are criminal penalties at all under the Electoral Count Act.
Okay, can you tell me, you've argued that he shouldn't have had the 3-point enhancement. What would that effect have been? If he didn't have it, what would his sentencing range have been as compared to what it was here?
I can't remember the exact number, but it's significant. It's about a year difference or something for 3 points. And it's especially significant here because the judge sentenced the exact low end of the guidelines. 24 months was the low end. And he even specifically said, I'm doing the low end because I might vary downward, but these reasons don't apply.
So you've argued for it to be overturned, but haven't given the court any information about what, if any, consequence that would have for his sentence. If the 24 months would still be, even if the range shifted, it may well be that the 24 months would be at the high end of the new range rather than the low range, but his sentence might well be within the adjusted range, or it may not. I'm asking because I don't know.
The sentencing guidelines would certainly be lower. I just blanking on the exact number, but it would be a significant lower sentence. And I think the law is clear that if there's a mistake in the sentencing guidelines, the judge could impose the same sentence because post.
No, I understand. I'm just trying to get a sense of whether the sentence that he received would even be in the ball, even be absent of variance or departure, whether that would be even a permissible sentence or not. But I just don't know the answer to that, and I take it you don't either.
Yeah, the guidelines would certainly have been significantly higher had that enhancement.
That doesn't really answer the.
Maybe I'm not understanding Your Honor's question.
It would be helpful maybe on your rebuttal if you could tell us what the new guidelines range would be without the enhancement.
I can do that, Your Honor.
Right. Okay. Any other questions for my colleagues? Judge Rogers? All right, thank you very much.
Thank you, Your Honor. Thank you.
Good morning, and may it please the court, Eric Hansford for the United States. Sufficient evidence supports the defendant's conviction for corrupt obstruction of an official proceeding under 1512C2. And the district court properly applied the guideline under the enhancement under guideline 2J1.2 for substantial interference with the administration of justice. I'll start on the 1512 issue. This court need not get into the issue that's currently pending before the court in Robertson, because the most that's preserved in this case is a challenge to the sufficiency of the evidence in this case. And under either the Fisher concurrences standard for the sufficiency for corruption, or under the government's preferred definition of corruption, there was sufficient evidence in this case. As the court has noted in the earlier argument, that is a deferential standard. Under Bryant, this court applies the same standard to district court, to bench trials as to jury trials. And there was sufficient evidence in this case under either standard.
But the district judge did not make any holding or findings to meet the standard. You're referring to the standard that Judge Walker would have applied?
That's correct, Your Honor.
Fisher? The district judge didn't purport to apply that standard or make any findings with regard to it. And is it your position that under Hilly, we nonetheless just assess the evidence?
That's right, Your Honor. And that there's no, well, the problem is there's no objection to the lack of findings under the benefit standard, that the benefit standard was never raised. We think it was invited error, that it was affirmatively waived, but whether or not you think it's invited error, at least clearly plain error in the district court. We also think that it's been forfeited in this court because it has not been properly briefed. All that's been said is that for the reasons stated in the Fisher concurrence, this court should apply that standard. That sort of incorporation by reference is not a way to preserve.
He's not incorporating another argument or something. He's incorporating case precedent and saying, for the reasons explained in the court's opinion, the concurring opinion, I adopt those same reasons as a concurring opinion. Those are the same reasons you should apply this test. I don't know why that's not, you were able to respond to the argument. I don't understand why that doesn't put you on notice and the court on notice of what his argument is, even if it's not skeletal, it's not hinting at an argument. We know precisely what he's arguing for.
Well, so two things. One is whether it's clear what's being argued or not. Incorporation by reference is not a way to preserve an argument.
Have we held that when someone says, I'm agreeing with X opinion?
I mean,
by reference, as I argued in my district court brief, doesn't count. I get you on that. Is there a case where we have said that? Or another court has said that as applied to, I'm all in with X opinion.
So, I mean, I'm not sure why that would be a different standard, but I think the second point is maybe more responsive to this, which is
citations and arguments about cases. And so if he's done enough to invoke the case law and stand on it, I don't know why we would, and you don't claim that you weren't on sufficient notice to brief the issue.
He's not asking for the concurrences standard, because the concurrences standard says that it is met by seeking to give a
different argument. The argument isn't about incorporation. The argument he's arguing something that he just wasn't argued brief. Period.
But it's both. That we don't know what his standard is. He's saying apply the Fisher concurrences standard, but he's saying the Fisher concurrence is applying the standard wrong. So we don't have a target to aim at in terms of what the actual objection is.
Consciousness of wrongdoing
Yes.
standard that the district court applied here.
Yes.
What does wrongdoing mean?
What does wrongdoing mean? I mean, I think the what's clearly covered is unlawfulness, which is what North.
Sorry, so you need to be conscious that you're violating the law?
You need to be conscious.
Specific intent. Didn't we say in, I think, North that corrupt is more than specific intent?
So corrupt does require a specific intent, as in an intent to impede, which is kind of a separate
But
requirement.
not specific
there. But-
intent in the sense of intent to violate the law as such.
I think we rejected that. did we not?
So consciousness of wrongdoing means you are aware that you are at least violating the law. We do think it's broader. We think wrongfulness is broader, and we think that's.
What is it? I'm really, so tell me.
So
You have to at least have this, but is that enough?
So it's sufficient if you are conscious that you are violating the law. It would also be, I think we haven't had to go beyond that in the January 6th cases, but I think it would also be sufficient if you understand that what you are doing is improper, potentially breach of court rules or something that wouldn't necessarily impose legal standards. But January 6th, these January 6th cases, all this court need resolve is that you are consciously violating.
It would be helpful to have a standard. I understand that wrongdoing encompasses independently unlawful conduct as well as conduct that might not be independently unlawful. And one obvious candidate in the latter category would be lying. Lying isn't always unlawful, but someone who acts in a way that, they lie to get what they want. They run into the Capitol, a lone person, and say there's a bomb threat when there isn't.
Sure.
Even if that weren't independently unlawful, if they're doing that in order to stop the electoral count, presumably that would be corruptly. And I guess I would like the government's help. That as I read consciousness of wrongdoing, its origins are in the Arthur Anderson decision, and it's not used there as a legal standard. It's used there as part of the description about why the Supreme Court found the conviction inadequate, because the way that the jury had been charged stripped out any consciousness of wrongdoing, any purpose or intent or mens rea standard. And then it seems like in these January 6th cases, consciousness of wrongdoing has become this sort of, as if it's a legal standard. I'm not sure that it is, and I'm interested in the government's view about what is the, do you have anything more to say about corrupt purpose other than that it is met, in your view, by, I'm not sure what, some kind of intent or awareness or intent to do things that the law independently forbids?
So I mean, to start with the premise of the question, I think consciousness of wrongdoing is a legal standard. That's where we take that from Arthur Anderson. And I think, Arthur Anderson may be frustrating in kind of failing to spell out exactly what all of this means, but these are standards found in Arthur Anderson. Arthur Anderson says the problem in that what is corrupt is what is wrongful. And the problem in that case is that the jury was not told that they needed to find consciousness of wrongdoing. And I think multiple circuits have then taken that and applied that standard and have asked for that standard to be met. And so I agree, it's not kind of a traditional mens rea in terms of purpose, knowledge, recklessness, negligence, but we read Arthur Anderson to say that is the legal standard that is required.
I urge you to reread Arthur Anderson. The court says that knowingly doesn't modify, corruptly persuades. The Supreme Court says that corrupt and corruptly are normally associated with wrongful, immoral, depraved, or evil. Only persons conscious of wrongdoing can be said to, quote, knowingly, corruptly persuade, close quote. And limiting criminality to persuaders conscious of their wrongdoing sensibly allows the statute to reach only those with the level of culpability we usually require. So basically the court is saying, we usually require some element in the criminal law that defines the requisite consciousness of wrongdoing. And it seems like the government has just taken that phrase, you need to pick some consciousness of wrongdoing, and declined to pick any consciousness of wrongdoing.
I mean, so just in what the court read, I think it's the prior sentence before the Aguilar and Liberata cites. It's the sentence before that. The only persons conscious of wrongdoing can be said to knowingly, corruptly persuade. I think that's where corrupt consciousness of wrongdoing is imposed as a legal standard. It's not the Supreme Court says in the next paragraph, we're not sketching out the outer limits of it, which is
right.
Why
the
we're
outer
here.
limits of this element need not be explored here because the jury instruction at issue simply fails to convey the requisite consciousness of wrongdoing. So it's pointing to a variable, a type of element needed in a criminal case, and not resolving that. At least, I mean, I guess maybe another way to get at this is, can you respond to Mr. Burnham's concern that consciousness of wrongdoing is a very capacious standard, and someone who's, thinks it's wrong, not to address people with formal titles could, be conscious that they erred in that way, or.
So I mean, I think the narrowing construction here is the unlawfulness. It's that you need not, although wrongdoing, as in Arthur Anderson, you need not explore the outer boundaries. If you are conscious that you are acting unlawfully, then you are satisfying that wrongdoing standard under any.
It's unclear to me whether you're saying in the sort of a Screws type specific intent, you have to be conscious that it is unlawful to be in a restricted area. Do you have to be conscious that it is unlawful?
You
to
don't
be disruptive in the Capital?
So you don't have to know kind of chapter and verse of
I take that to
Title
be your
18.
view, yeah. So how
Correct.
does it get into the mens rea element?
But you have to be aware that what you are doing is not allowed by the law.
So
that is
when you say you don't need chapter and verse, what about all these demonstration cases? In other words, you may, as a future defendant, believe in the righteousness of your acts and for a higher purpose. But someone who, so far as appears, is a representative of law enforcement, states that you must leave, and you'd fail to leave. And then with the other things that Judge Pillard mentioned in questioning appellant's counsel, that you have that consciousness of wrongdoing that rises to the level of corrupt behavior because of at least, and this is where it's tricky for me, the law enforcement representative represents that you are interfering with a lawful, otherwise lawful congressional proceeding, indeed one constitutionally required. Why isn't that critical in these cases? I mean, I haven't studied each and every January 6th case, but the cases I have looked at, there has been advice before arrest, or there have been the traditional law enforcement symbols, namely barricades, signs, etc., that are being ignored. And why isn't that sufficient? And I guess the next question is that going to always be sufficient for purposes of corruptly, or has corruptly been watered down to this notion of consciousness of wrongdoing?
So you do have that sort of evidence in this case. You've got that Judge Bates finding it's inconceivable that he wouldn't have noticed these overturned barriers, that he's walking in next to broken windows, that he's walking past police officers, seeing officers assaulted. And just in terms of your question, it's important to note, consciousness of wrongdoing is only one requirement of the corruptly. In addition, there's a requirement that you be either using unlawful means or be acting with an unlawful
Well,
purpose.
this is the unlawful purpose. I thought that's what we were talking about.
Right, yes.
I'm
Isn't
now
that
completely
the
confused.
argument appellant's making.
I mean, I guess I'm confused as well, Your Honor. I thought we were talking about consciousness of wrongdoing and what is required by consciousness of wrongdoing.
I thought consciousness of wrongdoing was the corrupt purpose that you were standing on
So
in this case. That I know that some of the jury instructions have layers of, knowledge and conscious wrongdoing and, unlawful purpose or corrupt purpose, but that's belt and suspenders. I was asking, what is the government's view? And the way this case was tried and the way it was decided, well, I should say the way it was decided was on, when you're talking about corrupt purpose or corrupt means, it was decided on the corrupt purpose avenue. Am I right?
we think the jury or the district court's verdict also supports corrupt means, but I think that is not explicitly what Judge Bates said, although he made findings that would also support corrupt means.
All right, setting that aside, because the district court, as I read it, only made findings with respect to corrupt purpose. Is it your view, what counts as corrupt purpose under 1512C?
So wrongful purpose, which I understand the court's frustration with the term wrongful, but that
So you
is.
are arguing that, because then you were,
So-
I thought you were answering, I'm sorry, I interrupted when you were answering to Judge Rogers and you said, well, it doesn't only require
Right.
a consciousness of wrongdoing, it also requires corrupt means or corrupt purpose. And that's where
Right.
you brought me up short, because
Okay.
that had not been my understanding.
Sure. So the government's position, which I think is laid out in our brief and in Robertson, is there are two prongs that as to what corruptly requires. The first prong has alternatives. You can either act by corrupt means or corrupt purpose. The second prong, which has to be additionally satisfied, is you have to have consciousness of wrongdoing. You have to meet either corrupt means
Consciousness of
or
wrongdoing alone is not enough to establish.
Correct. Consciousness of wrongdoing. I mean, in many cases, it could, the same evidence may well be establishing these things. But what you have to know that you are doing wrong, and you have to either be acting independently, unlawfully, or have an unlawful aim. Here, the unlawful aim would be overturning the election through improper procedures, what he describes as, I'm ready to actively rebel, I'm engaging in insurrection.
Okay, so what's a corrupt purpose? If I know I'm breaking the law, but that's not enough, what is a corrupt purpose?
So a corrupt purpose is what you are intending to do through your actions. So you are breaking the law when you are standing up and shouting in sure. The fact that you are breaking the law is not enough. You're also looking at what is your purpose in acting here. And in the January 6th cases, the purpose in acting is to overturn the election through not the normal channels, not the lawful channels. And so that is the purpose with which Brock and many other January 6th.
If a civil rights protester wants to go sit at a lunch counter and knows that they're violating city law, maybe even state law, but also knows that what they're doing is protected by the Constitution, or believes that it's protected by the Constitution. Let's say the Supreme Court hadn't ruled yet, but there's a pattern of case law. They believe it's protected by the Constitution, good faith and reasonable belief that it's protected by the Constitution. Is that knowledge of wrongfulness or corrupt purpose?
I think if they believe it's protected by the Constitution, then I think they presumably wouldn't have consciousness of wrongdoing. No.
So then isn't that Mr. Brock's argument here that he thought, yeah, all right, maybe I'm violating some, or maybe the court could find that I was breaking some rules governing the conduct on the Capitol grounds. But in his view, a greater constitutional harm was occurring and the Constitution properly applied and implemented, I'm just describing his view, required that electoral vote count, which in his view was all fraudulent, stop and the right one occur.
So
How is that, if he thought violating local law, but I am doing it in service of the correct constitutional, what the Constitution requires, which is an accurate vote count, and he didn't think that's what was going on.
So there's nothing in the record to suggest he thought this was protected by the Constitution. The record evidence is that he thought it was kind of a greater good in the sense of, a pro-life person might kill an abortion doctor. Or
No, I think he was clear. He thought that in fact what was going on, again, these are just his view, but we're talking here about a mens rea, that what was going on was actually a corrupt, fraudulent vote count, that wasn't the true electoral outcome. And the Constitution, of course, requires an accurate electoral count of the true electoral votes. Now, he could be factually wrong, but he thought he was doing, and you said, reasonable good faith belief that that's what the Constitution required. If he had at least a good faith belief that that's what the Constitution required, that this vote count stop, it's disenfranchising me and everybody else who voted otherwise.
So
Why isn't that, how is that different from the civil rights protesting?
I mean, because so first, I'm not adopting a good faith, reasonable belief standard. I don't think kind of the exact standard would have been briefed here, but there is no evidence that he thought that what he was doing was proper, that he was allowed to interrupt the
Allowed
Congress.
by the Constitution?
Allowed by the law, yeah, Constitution or statutory.
I think, and again, not to equate what happened with civil rights protesters, but just mentally, you have the thing, at least in his view, the Constitution required a different electoral vote process than was occurring, and he's feeling disenfranchised. Or if he's not, then just say my hypothetical protester does. It's being disenfranchised. And so I don't believe I'm engaged in knowing law breaking. I believe I am engaged in constitutional vindication. It could be wrong. People at the lunch counters could have been wrong. It turned out they weren't, fortunately for our country, but they could have been wrong. The Supreme Court for many, many, many years before that would have said you don't have a right to sit at the lunch counter.
So the layering on of the Constitution is not what was argued in this case. He's been arguing greater moral good, not I believed that my actions were actually constitutionally protected.
We argued, and it's in your brief, you wanted a clean slate of electors submitted to Congress.
But
you wanted them voting on what he called a clean slate of electors. I'm quoting your brief.
So this is kind of a reasonable jury argument that he actually thought that he was not doing wrong. Was not violating the law. That is a jury argument you could make. Whether or not something statutory in the Constitution.
Is what you would tell the jury if someone said, say he has your perfect record for this. What would the instruction be to the jury on what the consciousness of wrongdoing is when the defense is, I believe I'm protecting and defending the Constitution, but I admit I'm breaking local laws?
I mean, I don't understand
would that meet consciousness of wrongdoing?
So no, I don't understand the distinction between breaking the law and protected by the Constitution. If it's protected by the Constitution, it's not breaking.
I mean, it's easier if you think of it in the lunch counter sit-in. Clear violation of state and local law, but clearly permitted in this person's view at the time by the Constitution. Is the only difference that they turned out to be right?
No, Your Honor. I mean,
They both
it's,
have consciousness of wrongdoing?
so the protester is obviously not guilty of obstruction for many other reasons. There's no official proceeding.
But they're
et cetera.
guilty.
No, I'm just asking
but
about consciousness
sure,
of wrongdoing.
sure.
I'm not
So-
going to say the statute.
So
I'm
the,
asking whether they knew they say, I know, they knew, that's what the civil rights protesters, they knew they were violating local laws, and they did so to advance their view of what in fact the correct constitutional rule of law is.
if you think your activity is constitutionally
I'm not saying
protected,
what I'm saying what you think. This is what I think. I'm trying to learn here, so.
if the protester thinks that the activity is constitutionally protected, then yes, they wouldn't think it's unlawful. I mean,
Okay, so
that's,
if-
that goes,
They
but
wouldn't think it's what?
they wouldn't think it's unlawful. What the Constitution protects
Yeah,
is
but
not.
you know, the lunch counter cases, that's one set of demonstration cases. There are other sets of demonstration cases where people thought they were pursuing a constitutionally protected right. And yet they failed to get that recognized even to this day by the Supreme Court.
But
So
Right.
I'm getting what I'm trying to get at. That's why I thought you were arguing what I had asked earlier, but now it seems we've gotten very far afield. And what I thought the district court was doing, and I thought Judge Pillard's question to appellant's counsel was getting at, was given everything that was going on, the objective facts were such that no matter how righteous you may feel in your personal action, no one, and at least a fact finder could find, no one in that position would be able to think rationally that this was lawful conduct. There are many ways to challenge an election. There are many ways to challenge a certification proceeding, as this legislative history no one apparently has read or even considered discusses. So this is not the end of the matter. And I've been trying to come up with something that's relatively clear. And I thought that's what Judge Pillard's questions were trying to get at, so that we don't have this fuzziness. But it seems to me that, you know, if we're into constitutional rights and looking, you know, 20 years down the road at what the Supreme Court's going to do to your claim of a constitutional right, that's not the way the law has proceeded, even in a lot of these demonstration cases. And I'm thinking, for example, of one's claim to, you know, equality of spending on public education. That's one area. So I'm not sure why the government wants to go too far in this matter, when what I thought the district court was focusing on was taking everything that's relevant here. The evidence
I completely
was beyond
agree,
a
Judge.
reasonable doubt. What?
I completely agree, Judge Rogers. I think that is the standard that the district court was applying, was applying the standard of there is no, was finding that Brock did not believe that he was acting lawfully, was applying that, was making those findings based on the full facts of the case, that there are ways to kind of, you know, contest the election, but it's not through rebellion, it's not through insurrection, it's not through kidnapping members of Congress. So I certainly agree completely with what the question is, and we are not seeking to go down the road of.
The problem is that you've said the two-part test, consciousness of wrongdoing and improper purpose.
Or
And the-
independently unlawful means. Yeah, or.
But the district
correct.
court said corruptly requires showing dishonesty and improper purpose or consciousness of wrongdoing. Did not do the two-part
Right.
test. And so we're back to struggling with what's required and what was shown on this record. Do you think the court erred by not separately finding corrupt purpose?
So I mean, we acknowledge that in our brief, we acknowledge that is not the proper articulation. There's kind of problematic bracketing if you go back to the decision that's being quoted. But our argument is that in the full record, the district court did make the necessary findings. And the defendant is not contesting that in his briefing and did not object below.
Say, I find both consciousness of wrongdoing and in addition, presumably based on some additional evidence, I provide, and a different legal test, I provide corrupt purpose. Excuse me, I find corrupt purpose.
This is our paragraph on 28 to 29, the carryover paragraph.
I'd like, can you point me to district court's decision?
Yeah, so the findings we point to there are more, is A 462 to 463. Brock's Facebook messages support that he knew obstructing the election certification on January 6th was improper.
Sorry, you JA page what?
462 to 463. And then A 475, Brock acted with the intent to do something that the law forbids, that is to disobey or disregard the law. So
that's the consciousness of wrongdoing.
That is the consciousness of wrongdoing, yes. And
where's the corrupt purpose? Where did the district court know he was finding something separate from consciousness of wrongdoing?
So first, these are not preserved objections on appeal. They're not preserved objections. Sure.
The government's here telling me the government's the thing when the government's up here, if they're telling me the district court didn't make the right legally required findings.
Well, our position is the district court did make the right findings. Right. So it's A 462 to 463.
Okay, so tell me.
Brock's Facebook messages. He flipped to it. Brock's Facebook messages support that he knew obstructing the election certification on January 6th was improper.
Right, but he's done this. His opening line is, "Fourth, I find," and it's what I quoted to you, that dishonesty and improper purpose or consciousness of wrongdoing, right? And so he's going here through, it's all proving the one thing, right?
If the court thinks that the district court was not, we've argued the district court was applying the right standard, that we acknowledge that or should not have been bracketed like that. If the concern here is that the district court might not have been applying the right standard, which is not preserved below and is not preserved on appeal, but it would not be, improper to remand for clarification as to that specific finding. But that is not the kind of larger legal issue that's either being argued or the definition of corruptly.
Right. So I can't, on 463, can I just tie this up? Sorry. On 463, he says he clearly intended to take very purposeful actions to interfere with any certification of the election and even to take actions that warranted on violent conduct. And you're saying you clearly intend to take purposeful actions to interfere with the congressional proceeding? Is that an improper purpose?
So
because our cases are filled with examples of that are perfectly legitimate.
The quote in our brief, I'm trying to find it in the JA, but is on 462 to 463, Brock's Facebook messages support that he knew
that's on 462, lines 11, 12, 13.
That he knew obstructing the election certification on January 6th was improper.
But then he continues with, he was prepared to break the law. And I aim to misbehave.
Right.
Hoping we don't get arrested, which I'm having trouble understanding. Is that consciousness of wrongdoing or improper purpose? Or is there a difference between the two? Not really a difference between the two.
So there is a difference between the two in the abstract, but I think those findings.
The abstract doesn't, it's in the law.
Well,
an articulable difference in the law.
In the law, yes. If you know you are breaking the law and if you have a unlawful purpose, those are different standards that you're asking the jury to to find,
Unlawful purpose is trying to make Congress stop doing.
to overturn the election through unlawful means.
Unlawful means.
Well, then you're
That's
just
not the corrupt purpose, then you've added unlawful means. So let me ask a slightly different question, but it's related,
Sure.
which is in North, this court talks about corruptly, and I'm in North on page 882, Federal Reporter Second 882, where court says, in the context of judicial proceedings, corruptly means nothing, some is referring to other courts of appeals, means nothing more than an intent to obstruct the proceeding. And in doing so, they haven't read the corrupt intent requirement out of the statute. And it goes on and says that there are very few non-corrupt ways or reasons for intentionally obstructing a judicial proceeding. And then the court talks about when someone is intentionally obstructing a judicial proceeding as structured and not open to lobbying and legislative jousting as a judicial proceeding is, an intent to obstruct it, is itself presumptively corrupt. And then the court goes along in the second sentence and talks about, well, unlike courts of law, congressional committees are part and parcel of a political branch, wide-ranging functions, not limited to a search for truth in accordance with formal rules. They may have far-flowing investigative scope and evoke legitimate political jousting. So in that context, we need more than intent to obstruct the proceeding. This is a lot of
Sure.
lead up. But my question is, in the context of the certification of the electoral count, given how formal it is, given how structured it is, given that it's not open to political jousting, is it the government's position that an intent to obstruct that proceeding is an intent to act corruptly? And I'm bracketing not an intent to influence, but an intent to obstruct, or we could even say an intent to obstruct by mob.
I mean, that is not the argument we've been making. We do view intent to obstruct as a wholly separate element, separate from corruptly. And so Judge Bates gave a separate finding that there was an intent to obstruct. I think that was his second element. And then the fourth element was also there was corrupt acting. In terms of whether or not in practice, those will often collapse, if that's the court's question, or conceivably whether.
Would it be enough if a district court in a bench trial said, I find consciousness of wrongdoing because of the visuals of overcoming the police and storming the Capitol, broken windows, alarms, and I find a corrupt purpose because there's a purpose to, by mob action, obstruct this proceeding? And when you say conscious of wrongdoing, that this is and maybe this is a means question, but at some level, as you point out, the evidence of the two avenues may overlap, and
Right.
So a purpose to obstruct by mob, it seems like you're having a purpose to act. Maybe there's a higher purpose that could be served through First Amendment protected means. But when the purpose of this conduct is to obstruct by mob and strike terror into the hearts of the lawmakers and cause the Secret Service to take them off site, and, or something along those lines, wouldn't the purpose or intent to obstruct this proceeding by mob action, what more corruption do you need?
So
Independent and lawful action.
with the kind of proviso that, I can't kind of bind the department to future prosecutions or positions, it would seem in thinking through that right here, that would, if you've got a district court who's making those findings, who's making the findings that obstructing January 6th, the electoral certification by mob action is going to establish corruptly because it's consciousness of wrongdoing. Anybody who was there would have understood it was unlawful. And there's both, I would
Is
say.
mob action any different than unlawful action? I'm not even sure what you mean by mob
I'm
in here. If you had a majority of the members of the House and the Senate who decided we're not showing up, so there's not going to be a quorum, whatever's required for a quorum. I'm assuming majority, maybe it's even more than that. But there was a large number of senators and representatives grouped together and said, we are going to prevent this proceeding from going forward by denying it a quorum. And we're going to act in unison. Are they acting with a corrupt purpose?
So just to finish the answer to Judge Pillard's question, I never really got to the punchline, which is that I expect that we would defend that if you had proper district court findings that you could infer corruption based on those facts, based on the mob action. I think in terms of legislators acting, there's a whole slew of additional kind of constitutional considerations that I'm frankly not prepared.
Okay, so then what if I've got a bunch of citizens who are all calling their members of Congress and trying to influence them to boycott the electoral vote count en masse to deprive it of a quorum? Are they corruptly interfering with the proceeding or corruptly attempting to interfere with the proceeding?
Let me just interject here an inconvenient matter. The legislative history is just critical here. And the Supreme Court has directed us to go back to look at what the founding fathers had in mind. And the fact that during our lifetime and our parents' lifetime, the counting of the votes certified by the states in a presidential election has been a very formal, non-controversial matter, is not dispositive. So the premise of Judge Pillard's question, some of the assumptions under Judge Millett's questions, if we follow the Supreme Court's direction about what was the intention in setting up this process back in 1886, then that legislative record becomes relevant. And my only point is, I don't find any notion about disruption and breaking in and that sort of thing and seizing members of Congress. But I certainly do find evidence that it was not uncontemplated that in this quasi-judicial proceeding, members of Congress could ask questions, could seek evidence, if they were concerned about the lawfulness of the certification of the votes from a state. So that if that is the correct reading, then the fact that citizens call their elected representatives and ask them to raise questions on the floor of the Senate at the time of certification, it seems to me that can't even be close to corrupt action, at least as this whole process was understood back in 1886.
I think that seems correct, Judge Rogers, and I think that does bring us to the meaning of administration of justice, which relates to this, which is the quasi.
Question.
Sure.
Not asking them to ask questions on the floor of Congress, but to boycott the proceeding, depriving it of a quorum.
I have trouble imagining that as corruptly as I stand here trying to think through it.
Well, the rules of the
Clear.
Senate allow the calling for a vote of the presence or absence of a quorum.
Right. And so I think trying to do things within the
I'm fine with
legislative process.
Attempting to interfere with the proceeding. Again,
And that's the very
Put the people
purpose
together.
of calling for a vote often, that a quorum is not present, and therefore the vote cannot go forward, and therefore a bill will not pass as it was contemplated. I mean, that's a very political process.
Right. So I think if you're going through, as Judge Rogers is indicating, if you're going through the kind of legislative means, it's hard to get to corruption, to improper purpose, or especially to consciousness of wrongdoing. I do want to make sure I can address the administration.
One
Sure.
question, testing the boundaries of, you had emphasized the unlawful, like engaging in unlawful conduct.
Yeah.
As knowingly, I guess, acting in a way that the law defines as wrong, being part of corrupt purpose. If, we know that picketing in the Capitol is unlawful. If nobody else had shown up on January 6th, but a lone picketer was inside the Capitol rotunda with a picketing sign, engaging in a misdemeanor, would that person be employing independently corrupt means and thereby have that misdemeanor supercharged under 1512C?
So I think it probably, it's hard to get to charging that under 1512C2 because it's hard to see the obstruction or the impeding there, or
Influence?
well, or especially the
or attempted
intent to,
influence.
the intent to do so.
Intent to influence
So I think
through independently unlawful means.
so I think there's in the intent to influence, the obstruction, all of those, there's not every kind of action is going to satisfy those. Not every de minimis intrusion into the legislative process. And I'd say with the court's hypothetical, I don't think the definition of, I understand the court's discomfort, but I don't think the definition of corruptly is driving that. So if you take the Fisher concurrences formulation of what's corrupt, that there's a interest in getting an unlawful benefit. If that protester is standing there because he thinks he's going to personally benefit or whatever, or somebody else is going to personally benefit from the electoral outcome, I think you'd have the same discomfort with saying that's obstruction under 1512C2. So I don't think the discomfort is coming from the definition of corruption there. I think the discomfort is coming from whether or not it's actually obstruction or influencing or impeding under 1512C2.
But attempt counts as well. I'm just, this, I do think this, I actually think, I beg to differ. I think, at least what I'm wrestling with, I can't speak for the others, is what this corruptly word means and how it can be met. And, I'm not the first one to do this, to struggle with what that word means under this and related statutes, when as applied to Congress in a way that marches by constitutional line and doesn't impede, free speech or right to get in government for redress of grievances. And so I'm not sure why. I mean, I get that the government would have little incentive at that point. The attempt would be really pretty pathetic to do it, but that's I'm not sure where your definition of corruptly as a legal test, as a legal standard, and whatever's happened in history, now we're talking about prosecuting people for violations of the criminal law for felonies. So that's why I'm at least struggling to make sure that we have a concrete understanding of what the corruptly standard is. And I'm not quite sure why that person's out, other than any prosecutor who tried to bring it would probably get fired.
I mean, I think it is hard to imagine. One is that, obviously there have been lots of protester cases. These have not been brought as 1512C2 prosecutions. And two, I mean, if nothing else, prosecutorial discretion. But there is, in obstruct, influence, impede, even with the attempt liability, you still have to have a nexus to an official proceeding that's required by Aguilar and Arthur Anderson. And you still have to have not every kind of de minimis influence is going to qualify. Not every de minimis kind of minor interruption is going to qualify. You've got to have an actual intent.
Is that in the definition of corrupt, or is that simply because the Constitution won't let it?
That's obstruction. That's within the definition of obstruct, influence, impede. That those.
Influence?
So,
Okay.
I mean, they used them generous, like this is in the context of congressional proceedings. But I mean, this is far outside of kind of what's raised here. But yes, that not every kind of de minimis interruption of a congressional proceeding for 3 seconds is going to qualify. As to the administration of justice issue, so I think as we heard this morning, there is a definition of administration of justice that can focus on judicial proceedings. But we think the context of the sentencing guidelines in particular point to a different definition, which is that administration of justice is the companion of obstruction of justice. 2J 1.2 is the guideline for obstruction of justice. What you are doing when you are obstructing justice, you are interfering with the administration of justice. And that is how the guidelines use the term administration of justice. The larger term of Part 2J of the guidelines is offenses involving the administration of justice. That's their umbrella term. And then once you get to the, and then you've got various statutes cross-reference that fall within 2J 1.2. So you've got OSHA investigations and federal audits and tax audits. These are all considered obstruction of justice for purposes of the guidelines being sentenced under 2J 1.2.
I mean, it's tough and not very intuitive language, I think, for either of your positions. One of the things that strikes me about the examples that you give, although not themselves judicial proceedings, is that they are naturally at least a subset of those investigations do lead to court action. So it's sort of like an early stage in something that could, part of the reason someone might want to impede or obstruct OSHA or IRS process is because they don't want to end up in court. This doesn't seem quite like that.
So, I mean, I'd say two things. One is that I do think, especially based on the Electoral Count Act, the larger structure of the Electoral Count Act that Judge Rogers has been discussing this morning, it is a quasi-adjudicative act, very much that would fall if you're looking at quasi-adjudicative acts as administration of justice. I do think not everything Congress does, but this particular electoral satisfaction would satisfy that. But the second point is, in these in obstruction cases, you're normally required, not just in like 1503 obstruction, where you actually do have to have a judicial proceeding or a grand jury proceeding. You require a nexus to that proceeding. So the fact that conceivably way down the line, it could lead to a court proceeding, that's not normally what we require in obstruction of justice. And that's the Aguilar Supreme Court case that's saying, and Arthur Anderson emphasizes this as well. So I don't think you can just take those cases as, conceivably a tax audit. If things go really bad, that could lead to various, and I'm not sure that that's even true of most of the federal audit of how the federal government's using its money.
I mean, when you first think obstruction or interference with the administration of justice, you do think, as Mr. Burnham, I think, was saying, of a criminal court proceeding, not even maybe civil. But I guess one thought that I had, and maybe you've thought about this a lot more, substantiate or steer me away from this, is that putting that administration of justice or it's a little bit broader than that, a judicial or related proceeding that determines rights or obligations, that the writers of the guidelines don't want it to apply to obstructing any executive official or any court official in any activity. I mean, members of the public interact with administrative personnel in all kinds of ways. And so I guess that there is an effort to make it apply to some subset of more structured processes. And that, that's maybe a unintuitive, but nonetheless adequate way of doing that.
So, I mean, I think that our view is that administration of justice is not meant to be a limiting term. It's not meant to narrow the universe of when the enhancement applies. Instead, it's supposed to be the umbrella term for what happens when you are obstructing justice. And I think you can see that in the two enhancements. The enhancement is not for interference with the administration of justice. It's for either substantial interference or it's for assaulting someone, threatening someone, causing property damage in the administration of justice, and impeding the administration.
But all the
of justice.
commentaries examples, all of them involve things that are either judicial proceedings or investigations that could lead to either administrative adjudications or court adjudications. And the only thing that, there's a tail end thing or the unnecessary expenditure of substantial governmental or court resources. And your briefing relied a lot on the unnecessary expenditure of substantial governmental resources. That comes at the end of a list of things that are all sort of adjudicatory or pre-adjudicatory in the investigative sense. If all it takes, is it your position that if you can identify in any of these 1512 prosecutions, an unnecessary expenditure of substantial governmental resources, that's enough to apply this enhancement?
So
yes,
if you are causing that from your 1512 behavior, but in terms of that,
what's prosecution under any of the statutes? There's not a lot of statutes to which this enhancement can apply. What prosecution under any of those statutes would not involve the unnecessary expenditure of substantial governmental resources?
So we do not think that, maybe I misunderstood your prior question. We do not think that the costs of the prosecution are going to qualify as the substantial, the unnecessary expenditure of the government resources. So what we've been relying on is the damage to the capital in terms of those are the government resources we've been talking about. But you can look at the Second Circuit case in Palmer.
Investigative resources, are they included too? Investigating the crime?
We have not, that is not what we rely on in this case.
You may not have here. Is that what this language means? Because it's a necessary expenditure of substantial governmental resources. I just want to know what the government's position is, what that means, because that's a pretty sweeping language to trigger an enhancement based on specific offense characteristics.
So I think the view is that it's not the costs that are associated with investigating or prosecuting the crime. It's the costs that are caused by the interference with the administration.
He had, Mr. Brock here had a restitution order of, I think, $2,000. That was, is $2,000 restitution order enough to be a necessary expenditure of substantial governmental resources?
He's not challenging that on appeal.
I'm asking,
sure,
thought this enhancement. So that it was the $2,000, I guess, that he's held to be responsible for the capital damage.
So
specific offense characteristics. You can't go, everybody caused a lot of damage.
Right.
You got to show that he caused a unnecessary expenditure of substantial governmental resources. So the $2,000 that he did is what you're relying on.
So the $2,000 is how his part of the restitution has been separated out.
But his That's the damage to the Capitol for which he is held responsible.
Well, he's got collective responsibility for the damage to the Capitol.
Specific offense characteristic.
But it's a mob. I mean, when there's concerted action by a group of people and they all cause
Did
damage,
you find he was a conspiracy?
it's not a conspiracy, but it is a mob. And so we are relying on
Everybody who was there that day. Whether
It's-
they're in
it's
the Capitol or
part-
not. I mean, we're seeing pictures of people on lawn chairs sitting outside on the Capitol lawn watching what was going on.
So I'm not talking about people who are on the grounds, but in terms of people who are in the building, who are occupying the building, who are meaning to be part of the mob. I mean, that's how mob action works, is that it's a group of people who are joining together to interrupt this. So yes, we are,
Individual went in there, the individual protester by him or herself went in and knocked over something that was valued at $2,000. That would be enough to trigger this enhancement, or no? We really have to rely on he's responsible for what everybody did.
I think our position is that in this case, yes, that would be enough, but maybe I should walk that back. I haven't gone down that rabbit hole.
Is
He's
there-
not objecting.
Is there, he's certainly objecting to the application of this enhancement. Is there, and there could just be something I'm missing in guidelines or case law that allows these specific offense characteristics to be applied in this sort of what you call the collective action manner apart from conspiracies? Or is that something new to this?
I mean, I just haven't gone down that hole in the research. His challenge is a legal challenge. His challenge is to the meaning of administration of justice.
I
He
know,
is
but I'm
not
trying to get
making
to
a
that through the
factual-
language here that you cited in your brief, substantial, and the district court cited it too, unnecessary expenditure of substantial governmental resources.
Sure. So that is one of multiple contextual
And your
clues
view
that
is
we
that language means can be individual or collective? I mean, that's what you're arguing to me right now.
I believe that is how it was applied in this case, and he is not challenging that. I have not, the question of whether or not it's an unnecessary expenditure of substantial government resources is not what he's objecting. He's saying there's not an interference with administration of justice, because as a matter of law, administration of justice
This is
does not
interpreting
include.
what administration, I don't know how you can say this isn't relevant. This is interpreting what administration of justice means. It is the key language, the only language in the commentary that the court and the government could hang their hat on for how this was administration of justice. And so this is completely fair game. Because I'm trying to understand if we agree with the government, what we're biting off, what we're signing off on.
So I
We just say $2,000?
I do not think,
We
I
say
think
collective act, we either say $2,000 or we say collective action.
my recollection of the Amr Second Circuit case and the Ali Seventh Circuit case is the amounts are kind of comparable in that neighborhood. But I haven't taken the close look at the collective action.
Those were collective action cases.
No, those are not collective action cases, right? And I'm not aware of collective action cases, but I haven't looked for collective action cases because we're focused on the meaning of administration of justice, and there are numerous contextual clues
And if
beyond
Black's
that.
Law Dictionary defines administration of justice as, quote, the maintenance of right within a political community by means of the physical force of the state, or, quote, the state's application of the sanction of force to the rule of right, end quote. So can you tell me how this meets that? The administration, the maintenance of right within a political community by means of the physical force of the state. How does that apply here? Or do you not agree with the Black's Law? You had different Black's Law Dictionary definitions, but this
Right.
is actually of administration of justice.
Sure. And I think that whether or not you are retaining the presidency through the Electoral Count Act means specified by law does relate to the administration of right.
Maintenance of right?
The maintenance of right.
Who's right?
Excuse me?
Who's right? So you said that the maintenance of right
Sure.
is what the electoral count process does by means of
Right.
physical force of the state.
Right. Yes, in terms of who is retaining the presidency and how we are making our electoral decisions. But that's a hard definition to parse. And the contextual clues, and we certainly admit there are times when administration of justice is used in a narrower judicial sense, but there are strong contextual clues.
Almost far more commonly, it's used in the narrow sense.
Maybe somewhat more commonly, although I'm not sure the Seafried, for example, the Seafried decision, which does this corpus lingus, forgetting the term.
Sorry, I'm missing what you're saying.
Sure. So Seafried decision looks at how a random sample of administration of justice is used in certain cases, finds 65% relate to judicial proceedings, but then it also finds 25% relate to police. And there are other categories,
right?
Right. Well, but I think once you are getting beyond judicial proceedings.
The commentary mentions investigations, felony investigations. So that's right there in the commentary too.
Once you are getting beyond judicial proceedings, at that point, I don't think there's a definition of, at that point, you're not in Brock's world of the definition of administration of justice. At that point, you're in a larger definition. So if you look at the definition of obstruction of justice, interference with the administration of law and justice, contempt which includes contempt of Congress, Black says, is interference with the administration of justice. So it can support this broader reading, and we've cited the case law, and contextually, it does, there are indications in the guidelines that it should bear that larger meaning. There are no other questions.
Rogers, do you have any more questions?
Yes,
Thank you. We've kept you up a very long time. Thank you for your help. Mr. Burnham, we'll give you 3 minutes.
If I can, I have two, I think, pretty quick technical points, and then I'll proceed to what the main
Do you have an answer to my question about the effect on a sentence?
9 months. That was the first one.
I'm sorry, it would take.
It added 9 months to the low end and the high end of the guidelines that the enhancement
So the new range, the range without the enhancement would be.
15 months on the low end and 24 months on the low end.
Got it.
The way it was, and that's what he got was 20. Thank you for that question. The second technical point is there was a discussion at the beginning of counsel's argument is about exactly what we're adopting by relying on the Fisher concurrence and whether the comments there about benefits to candidate Trump somehow contradict the theory. And I think there's an answer to that. We just have to remember that the Fisher case was an interlocutory appeal. And what Judge Walker was saying there was, well, maybe down the road, the government could put on a case that perhaps the unlawful benefit was for President Trump to win. And so that was just sort of saying it was premature. That's why it was a concurrence and not a dissent. And so that doesn't contradict the abstract theory definition that we're urging upon the court today. So that's the answer to that.
Like you said, if the government proved that benefit, then it would count.
Sorry, I didn't hear you, Your Honor.
I think his opinion said if the government proved that type of benefit, that would suffice as a relevant benefit for his definition of corruptly.
If the government proved it, but that would require proof, I submit, that the actions of the defendant were to confer an unlawful benefit on President Trump himself as a person, not the country, not due process, not the Constitution, and it had to be intended to be unlawful. And so that would be a question for evidence at trial, and there's all sorts of ways that issue could go, and I think the concurrence understood that. It was an unusual way for the case to come up to this court. There's not a lot of motions to dismiss granted in the district court because it's so easy for the government to meet that burden. I think that's why that was the way it was.
Mr. Burnham, under North, we held that if the defendant uses improper means, even if he has a legitimate motive, uses improper means, we don't have to inquire into the motive. That's enough. The knowledge that he's acting and in the way the law forbids, and that the means he used were illegitimate, sufficed. Why shouldn't we, or don't we have to affirm on that ground here?
Because that effectively swaps out the corrupt mens rea or whatever the mens rea is of the offense that the government's relying on to prove corruptness. If the argument is if you're acting unlawfully, that's by definition corrupt. Unlawful can be any sort of criminal offense. It doesn't even have to be a criminal offense. It could be a civil unlawful action, which might be a negligence standard. So the effect of looking at it that way, and I hope this answers the court's question, is to basically swap out corruptness, which is a relatively high criminal mens rea, and substitute it with whatever happens to be the mens rea for whatever the government's
How do you
theory is.
distinguish North?
Well, the North is a little unclear on that point. North says improper purpose could be sufficient, but part of the problem we have here is these adjectives sort of get switched in and out by different judges. Judge Bates at one point referred to malign, improper shows up in North, wrongful is also, the term you hear, the government struggled to define that. And effectively, we're at North in this collection of cases that the district courts have been relying on, effectively create a situation where the corruptness standard is tailored to fit whatever facts of the case happen to be. And the result is you have, substantial prison sentence being handed down and a shifting definition of corruptly with a statute that without a firm definition of corruptly, many judges have agreed they're highly problematic. So that's my answer to that. I think importantly,
As I read North, it says we don't have to give the additional jury instruction on his state of mind because it's sufficient that he chose, as the court put it, the dubious course when he could have chosen a legitimate course to accomplish his objective, and therefore corruptly is met because he used independently unlawful means when he obstructed.
well, the first answer is that's a different standard than what government is arguing. Even the government's not arguing for that standard. They agree that the wrongfulness and the unlawful means or purpose are two separate.
We need to apply our precedent. And I guess what's the objection that you would have? Assume that they did argue that, just to put aside the question about preservation. There's a lot of those questions, but under the law and our interpretation of the law, we have precedent that said corrupt purpose or corrupt means. And one understanding, the most clearly established stable understanding of corrupt means is means that are independently unlawful. And if that occurred here and those are not even on appeal, what more is needed? And what's the objection to relying on that?
I think it's been established that the North case is post ambiguous enough, and there's a possibility it could be regarded as a dicta that even the Fisher panel or the government didn't regard themselves as bound by that specific formulation of the test. So I think it's, in effect, the law of this court based on the Fisher decision that the intent of 1512 is an open question for this circuit, notwithstanding North.
Well, in a case where that's what the proof is focusing on, but in a case where, I mean, if the majority of the court in North, and if an individual chooses the illegal or dubious course, no further showing of corrupt motive is required beyond the intent to commit the obstructive acts.
Well, I think what the task for the court is, as I said before, to clarify once and for all exactly what this shifting collection of, Your Honor mentioned dubious, malign is another decision, improper, wrongful. Every case has a slightly different formulation of it. And I think the January 6th era, the pressing task for this court is to clarify what these shifting definitions mean in a way that can reconcile the extent to which North is binding on the court. Another point I want to have that answered Your Honor's question is I don't want to miss an important statement that my brother counsel made with the protester hypothetical we've gone back to several times. The answer to one of the court's questions was that if, let's say, a lunch counter protester genuinely believed that the Constitution justified their actions because whatever statute local ordinance that said only certain people can eat at this lunch counter was unconstitutional. Their conduct might be illegal, but it wouldn't be wrongful for the 1512 cents. And that's important because although counsel for the government denied it in response to questions, there is evidence in this case that Mr. Brock was acting pursuant to his understanding of what the Constitution required.
Sure, but he didn't think the Electoral Count Act or the process itself was unconstitutional.
Oh, we did. We actually,
No, he thought factually the evidence coming in was fraudulent. But he didn't think the legal process being employed, the legal rules, the statute being applied was unconstitutional. He just had a factual dispute about the evidence before Congress.
well, we don't have a legal.
He wanted to go through electoral count, correct? He just wanted different votes to be counted.
The crucial point, I think, is his statements.
I'm correct, right? He doesn't think the Electoral Count Act, there's no evidence in the record that he thought the Electoral Count Act, the statute itself, was unconstitutional.
It's unclear. The record cites say things like,
The statute was where does it say he thought that statute was unconstitutional?
it's unclear, Your Honor. In the record, there are,
Unclear, or it
Yes.
doesn't show it at all?
it's unclear from Mr. Brock's statements exactly what he's referring to. There are statements that we have to defend the Constitution, the communists are taking over the Constitution. And there's not, he doesn't go on to say because the Electoral Count Act is unconstitutional or the way the election was conducted is unconstitutional or something else. Neither would.
Normally, that's not specific enough to raise an objection.
Well, it's not really an objection, but it's more an
Well,
analysis.
what is it then?
I think it's the exact same issue that would be presented in the civil rights protester
That's
hypothetical.
right, and that's the question, that's what the question is getting to.
That's right. And so they wouldn't have a specific articulation of their constitutional theory. The courts wouldn't require that of a civil rights protester any more than we think they'd require it of a January 6th protester. The question all comes back
The
to,
analogy would be that the earlier meeting on January 6th defined what their definition was. That is where the president himself, President Trump, was present. But, we don't need to get there here. That's all I'm getting at, because the government has limited the scope of its charges against your client.
it has,
So
but
they may be, but nevertheless.
Well, we're on plain error review. Isn't that the more important barrier to your argument?
Your Honor,
Or your challenge to the definition of corruptly?
our initial contention is that it's not plain error review. We deny that
You admitted, you stood right there and admitted this, just what you were arguing here for was not argued below. So you're subject, is there an exception to plain error that you think applies?
we didn't argue in our brief plain error because this is an open question. Honestly, just be candid with the court.
I'm sorry?
I don't think this qualifies for plain error.
Because,
I'm sorry,
why?
because we admit it's an open question. There's not a binding.
That-
I will.
That's one of the first one is, is it already answered by the law or not? If it's not already answered by the law, it's an open question, you lose on plain error.
I understand that, Your Honor. Thank you, Your Honor.
Thank you very much.
Thank you to the
Both
court.
counsel for your time. The case is submitted.
Case number 23-5026. AP Bell Fish Company, Inc. et al., appellants versus Gina Raimondo in her official capacity as Secretary of the United States Department of Commerce et al. Mr. Hobbs for the appellants, Ms. Mishra for the appellees.
May it please the court, I am Tim Hobbs, counsel for the appellants AP Bell Fish Company, Southern Offshore Fishing Association, and the Gulf of Mexico Reef Fish Shareholders Alliance. We represent the commercial fishing sector, and we are joined by amici representing a broad coalition of charter boat operators, commercial fish distributors and processors, seafood processors, and restaurants, all of whom are concerned with the action being challenged in this case because it reduces the supply of seafood for consumers and undermines conservation of the red grouper stock of fish in the Gulf of Mexico.
It reduces quantity for commercial, right? I thought the whole effort of the rule was to stem or continue to stem the decrease in stock.
What the service did here, Your Honor, was reduce the overall catch limit that applies to both the commercial and recreational sectors.
For the purpose that was clearly stated.
For the purpose, in part, to cover the increase of dead discards in the recreational sector.
Right, and the whole emergency that the 2019 Act was addressed, right?
That's part of it, Your Honor. But then what happened in this case under Amendment 53 was that there was a further reduction in the overall catch limit to correspond with the change in allocation between the sectors and the need to account for increased bycatch and dead discards in the recreational sector.
Right.
Is that right?
Well, in the sense that that is the position your client is arguing.
I think that if you look at there's a chart, table 1 in Amendment 53. This is in the record joint appendix 3314. There's a chart there where it shows the change in the catch limits that would apply under each of the allocation scenarios that were being considered. So as the allocation shifts more to the recreational sector, the total catch limit comes down.
So you argue that the district court was wrong in when it says the continuation of the shift to the FEC reporting system did not change or enhance the recreational allocation beyond what it would have been under the old system?
I think what happened here is that, so there was a new survey that showed that the recreational sector was catching more fish than previously estimated. And so what the service did was to increase the allocation for the recreational sector to match the new survey results. That essentially, prolonged the recreational fishing season around to where it would have been, but for the change in the.
So my question was, is it your position that the district court erred both as a matter of law and fact in its discussion of what the agency was doing when it was continuing to switch over to the FEC?
But my sense is that the district court accurately described the background and how we got here. I think the problem here is that there was this new survey that showed higher catch in the past, and so the allocation was reset to match that survey. But what the survey also showed was that bycatch and dead discards in the recreational sector were far higher than previously estimated. And so a change was made to give the recreational sector the benefit of its increased landings in the past. But then nothing was done to account for this increase in dead discards that the new survey results also showed.
Let me just back up and ask you, just sort of probe why it's seen as a new allocation at all. because one way of looking at Amendment 53 is that it restates in the new FES units the same historical allocation that Amendment 30B had expressed in CHTS units. In other words, both are allocating red grouper based on historical landings in the same period, 1986 to 2005. And the innovations are, one, the FES, which is not challenged here, and which, it's not that there's a greater allocation now under Amendment 53, it's that the service recognized that in the name of the 1 million pounds or whatever, you're on your chart, the top right cell showing one, that actually in practice all that time, it was much more and should have been, now that we have the FES units, 2.1. So it's not that they changed the allocation, but they acknowledged the existing reality of the numbers that have been relied on the whole time. And because they're using the telephone survey both to set the numbers and to follow up, just the whole thing was undercounted. But so that's one change. The other change is that there's a new lower fishing limit, which I took to be based on the stock survey. When you realize more are being fished, you had to bring it down, that it wasn't because there was this greater allocation. It was just, we have to be careful about not only current fisher people, but future fisher people, your clients. So I guess the basic question was, why is there a new allocation at all?
Well, so you are correct, Your Honor, that what the service did here was essentially take the new updated numbers, plug them into the old allocation formula, and then that spit out the allocations that resulted from Amendment 53. That portion is correct. So in a sense, it is updating the allocation to reflect the latest information. But the problem is that the new information also showed something new that was not previously understood. And that is that the bycatch and dead discards within the recreational sector is significantly higher than previously estimated. And so our concern is that nothing was done to address that piece of the issue. So there were two new things that we learned. The service updated the allocation to deal with the increased landings, but then nothing was done to offset the increase in dead discards that also were learned about as a result of the new survey.
Are you saying an increase in dead discards apart from the fact that when you recognize the recreational sector is more active than you thought, and it has a higher rate of dead discards, that along with that comes a realization that the fishing activity overall is yielding a higher number of dead discards? That's what I thought the case was, not that there was some separate study about the rate of dead discards.
That's correct, Your Honor. It's not a separate study. It was the same survey that showed both higher landings, or the amount of fish brought to shore, but also higher rates of dead discards in the fishery. So fish that are thrown away dead and not retained and not brought to shore, essentially wasted. And so
Weren't there three things, the two things you've mentioned, but also real concerns about death from these algae blooms?
That's right, Your Honor.
And so what happened here is the agency had either two or three, depending on how you describe it, as Judge Pillard articulated, sources of information to address. And that is, there's a lot more recreational fishing going on. There's a lot more discards, bycatch, and a lot of it's, and a even higher percentage of that is mortal bycatch. And we got a problem because these fish have already been harmed by multiple algae blooms. So they had a whole bunch of new data, new information, updated information before them. They said, all right, we got to come up with a new plan. So there are three things, not just the two, correct?
That's correct, Your Honor. And I think that's actually shown in the chart that I just called Your Honor's attention to. if you look in that chart, there's a column for the ACL. There's a number 5.35. That's what the catch limit would have been previously before Amendment 53 took effect. Then if you go down to alternative 2, which
I
is,
thought alternative 1 was the status quo ante. Oh, alternative 2, retain current percentages. So that's just translating to FES.
correct, Your Honor. So then if you go look at alternative 2, the catch limit is reduced from 5.35 to 4.90. Okay. My understanding is that that reduction is attributable to the guidance that came from the stock assessment, taking into account things like red tide and the need to be conservative in managing the fishery. But then if you
Go ahead.
if you go down to the next alternative, alternative 3, which was selected in this case, it shifts the allocation and the catch limit decreases from 4.9 to 4.26. So that is a reduction of 640,000 pounds that is attributable to making up for the shift of allocation to the recreational sector and the harm that will be caused to the stock as a result of that shift. So the service recognized that the overall catch limit would have to come down for both sectors in order to make up for the increase in mortality from shifting more fish to the recreational sector.
But you keep saying shifting more fish to the recreational sector. And I'm not sure I follow that, because it's a recognition of activity that was going on at this much higher rate all along. It just wasn't acknowledged or understood. And so really this interesting comparison is if you look at, on the top line, alternative 1, commercial ACL 3.16, and then recreational ACL, the second column expressed in FES units, 2.1. And all that alternative 3 does is effectively say, okay, now that we know the reality, what has been going on all along and what has been approved under an unchallenged alternative 1 scenario, or at least not unchallenged in this case, is actually different. It's actually better expressed as 3.16 versus 2.1. And now that we know fishing activity overall and the stock that we've studied, we're in trouble, we're on a collision course. So we're going to take both of those numbers down about 20%. And that, so we see 3.16 versus 2.1, it's about a 60-40. And then on line 3, on preferred alternative 3, 2.53 to 1.73, it's about 60-40. So this narrative about, I understand people perceived it that way, but this narrative about a shift of allocation to the recreational sector appears to me to be entirely illusory.
Well, I think it's correct, Your Honor, that if one is looking strictly at the number of landings, so fish brought to shore, then you are correct that the effort there was to match the new allocation going forward with what in reality had been caught in the past. That is correct, Your Honor. But the new fact that was not addressed was also the increase in dead discards. And so the service attempted to address that issue, to account for that additional mortality by reducing the catch limit. So in this case, the reduction from 4.90 million pounds to 4.26 million pounds, that was necessary to cover the additional mortality on the stock that would result by shifting more fish to the recreational sector. On paper.
What if, even though they did the FES, the study that yielded the FES figures, nothing changed in the way that it was expressed for enforcement purposes? You had 3.16 to 1, and then knowing what they knew about that 1 is really supercharged, they just kept with the old landline methods, but knowing that what they knew, that they were on a collision course, they just shifted it all down 20%. in your view, what's the challenge?
So if, let me make sure I understand your Honor's question.
We got, I don't know if you could shift it down 20%. Oh, that would be tricky because once you haven't expressed it in the parallel way.
See, and that's the issue is that if you look at the 2.1 figure compared to the commercial figure, we're already at a 60-40 allocation.
Right.
Right. So there's
That's my
no
point, is that we were all along at 60-40 allocation. We were all along.
Correct, Your Honor. Yes, that's true. Looking specifically at the landings only. But I think
but that's a separate point. The point about the landings and, the service says, well, in the way we understood landings, built into that is a proportion of dead bycatch. And so we are accounting for that. And the way we're accounting for that is by actually keeping the allocation the way it was and recognizing that way of operating is going to rock the boat the least, but everybody has to belt tighten in light of that.
Understood, Your Honor. And I think that would hold, but for the new information that was learned about how many fish the recreational sector is actually discarding.
Was that new information? I thought they just like more fishing is happening in the recreational sector.
Right.
And we've always known that the recreational sector is much less efficient when it comes to dead discards. And because there's more of it, we have more dead discards. And so your view is that there needs to be a permit system for the recreational side, or there needs to be...
We're not here to take a position on what the proper solutions are for the recreational sector, but we do think that there are many tools that the agency has at its disposal to get at this issue about dead discards.
Well, give me your favorite example. I mean, Louisiana says, like, this is what recreational fishing is.
Sure, but I think we reject the premise that recreational fishing is immutably, dirty and unaccountable.
That's why I'm asking you, what do you see that is consistent with what recreational fishing is, which the statute?
Sure. So there are multiple examples, Your Honor. There are gear modifications. And in fact, the Coastal Conservation Association's brief talks about recent legislation passed by Congress called the Descend Act that requires devices to be carried on board vessels to reduce mortality of fish that are released.
What to be carried?
They're devices that essentially puncture the air bladder of a fish that has been brought up from very deep depths because gases expand as the fish is brought up. Oftentimes, the fish then floats on the surface and dies or is eaten by something else. So by puncturing the air bladder, they can be dropped back down to the ocean floor and released.
Prevent the bends.
Exactly, right.
Can they survive after their air bladder is punctured?
The some still do die. It's not 100% effective, but it does reduce the mortality. So that's one example.
They just die from now having a punctured air bladder.
That's also possible, Your Honor, I believe.
Wait, so you said this was your example of what would reduce mortal bycatch. And if it just changes how or where they die, that's not reducing bycatch.
I think studies show that it does actually mitigate the bycatch. So instead, it reduces it to some level. It doesn't eliminate the mortality altogether. Some still do die after being reeled up to the surface, having their air bladder popped, sent back down. I mean, there's obviously trauma to the fish, both from the hook and from the puncture. So some mortality does happen, but it's perceived to be less than the mortality that would happen without using this device.
Congress found that it is. It's before Congress, they passed the law or it's pending?
It's been passed and the law requires vessels to carry the devices. It doesn't necessarily require anybody to use them, but they have to be on board vessels.
So
that apply to, and then you pointed, I just want to follow up, I have to understand this. This applies to commercial fishers?
And recreational.
So every individual who wants to go fishing now has to have this little bariatric chamber for the fish?
Well, yes, I said it's not a bariatric chamber, but it's a crude device meant to address the same effects. Yes.
So every individual fisher person will have to have this under this new statute.
Each vessel is required to carry one. There's no requirement to use this.
Is vessel every boat? So anybody fishing off a pier doesn't have to use this.
Correct, Your Honor.
But anyone who goes out on a boat, even if their own rowboat, has to have one of these?
I think if you are actively engaged in the reef fishery that's at issue in this case, then you do. I don't think it applies just to
Actively
any.
engaged, does that mean you fish more than once? Or if someone just goes out, I'm trying to understand this.
But my understanding is that if you are engaged in fishing for red grouper or other fish, then you fall within the ambit of the statute and have to have the device.
And your point is, so what the fish says, Congress already passed this law, that the fisheries service could have required people to use it?
That's right. There's no use requirement. Must only have to be
Statute, but you're
carried.
saying the agency could require use?
They could require the use. In fact, they actually used to also, under regulation, used to require vessels to carry the same devices.
But if you said it's already passed as a law, that's sort of pointless at this point. It's
Right, so the agency, yeah, could require them to be used. There could also be time and area closures. As in one of the cases we cited, the National Coalition case, that was something that the agency looked at for a different type of commercial fishing. But you can close areas of, bycatch hotspots, for example. So the agency could say.
So how do you respond to the agency's position and the state's position that the agency was looking at these 9 alternatives, explained why it acted as it did, and that's all that was before it at this time? And yes, there are other things it could do, even beyond what you suggested, but there was no obligation that it do so at this time, when what was before us was, before it was the 9 alternatives.
Yes, Your Honor. So that, I think, brings us to our national standard for argument. And so what the statute requires is that for any allocation, it must promote conservation. And to Your Honor's point, while this may have been a change to reset on paper what was happening in reality, there's no debate that this was an actual formal amendment to change the allocation within the fishery management plan itself.
But
Is that accurate though? I
it
realize
was in the context of considering, as I understand it, the agency's alternatives that it thought would carry out its purposes at the time. Not that it couldn't do things in the future, but at least as to at the time, it really wasn't going to make much of a change, which was the thrust of Judge Pillard's line of questioning.
That's correct. Although
So why was it obligated to do everything that was possible on the table to address this dead discard increase?
So we are not arguing that the agency was required to do everything on the table.
No,
What we are saying
to do is something about dead discards. And the agency, as Judge Pillard's line of questionings and your answers made clear, it seems to me, that it stayed at this 60-40 allocation. Now it knew more, but what it was focusing on was the threat to the stock. And there were other problems with these other alternatives. So for now, it addressed what was before it. That's all I'm getting at. Not that there aren't things that can be done.
Yes, Your Honor, but by formally shifting the allocation on paper, the agency entrenched this issue with dead discards. It was
for the moment, when the question was, as a result of the updating and as a result of the continuation of this transition of counting. And so that's all the agency was dealing with at the time. That's what I want to understand. Why was it required to do more? I mean, we have all these cases, the agency can address these problems over time, periodically. It doesn't have to do everything at once. Congress has already passed the statute, so it's out there.
Yes, Your Honor. We would point to National Standard 4 of the Fishery Act, which says that an allocation must promote conservation.
Right.
National,
And I didn't think you weren't arguing that, but rather that you were arguing because of better knowledge, the agency now knows about this increase in dead discards because it knows that there's more recreational fishing going on.
right, and as a result of formally changing the allocation for landings to match what had been happening in the past, that locked in a higher level of dead discards going forward.
But you say formally locked in. I mean, for purposes of this rulemaking, yes, but it wasn't as though the agency said it was never going to do anything in the future.
Your argument is they have to comply with the national standards in this.
That's correct, Your Honor, and I think
it can't, your argument is more than that. It's that it cannot address it the way in which it did, namely by maintaining an allocation.
I think what we're saying here, Your Honor, is that by formally shifting this allocation, even with reducing the catch limit, the stock was still left worse off. So as a result, based on all the information we know now, as a result of Amendment 53, the stock is going to be smaller, it's going to be less productive, it's going to give off smaller yields in the future.
Well, yes, but the agency is looking long range. Is this the way toward better health? And you're saying, as I understand it, well, even if it is, there are other things that could help even more.
That's right, Your Honor. And I think that's why National Standard 4, sorry, go ahead, Your Honor.
You can finish your answer.
That's why National Standard 4 talks about promoting conservation. That's why National Standard 9 talks about minimizing bycatch. We think that these things must be addressed each time the agency takes a regulatory action, especially one that makes the stock worse off as a result of the decision it made.
That the stock is worse off, recognizes. So is it your position that once they did the fishing effort survey, that actually Amendment 30B's allocation itself became impermissible in violation of National Standard 4?
No, Your Honor, because that allocation was undertaken at the time using the best available information that was there at the time. So that was on the books.
But if they just said, okay, we're going to stick with the status quo, there's too much complexity between the sectors, so we're going to keep Amendment 30B's allocation going forward, that would not be a problem in terms of conservation?
Well, I think if you know, the conservation impacts would be much better, actually, if the existing allocation had been maintained. That's alternative 2 in the chart that we were talking about earlier. Maintaining the prior allocation at 76.24 would have resulted in a higher catch limit for both sectors, and it would have resulted in less overall dead discards in the fishery.
Unlawful, right? Because in light of the status of the stock, couldn't have acted.
No, alternative 1 would have been unlawful. Alternative 2 was lawful. That was simply updating.
Bring it down. Right. It seems though, like under your reading, I guess I'm not sure what the stopping point is. Under your reading of National Standard 4, any allocation to the recreational sector fails to promote conservation.
We don't think that that's the case, Your Honor, because we think that the issues in the recreational sector that lead to high bycatch can be addressed. We don't think that these are immutable characteristics of recreational
fishing. Any allocation to the recreational sector without additional bycatch measures, anti-bycatch measures, would be a violation of National Standard 4, in your view?
That is correct, Your Honor, because if you look at the statute, the plain language applies specifically to allocations, and allocations must promote conservation.
So until the bycatch rates for the recreational sector are improved, the service under your reading has an obligation to zero out recreational fishing. And then as it tests and understands that there are ways that are the best scientific evidence supports to minimize bycatch, then they can reintroduce recreational fishing.
We don't think there's a need to zero out recreational fishing.
I thought that was the logic of your position.
No, because what we're saying is under the status quo prior to Amendment 53, there was an allocation. It was implemented based upon the best available information in 2005. That has not been challenged. Those regulations are on the books.
But now we have the FES, and so we know that that is no longer based on the best available scientific information.
Right, but there's nothing
The
to,
best available scientific information is that it's more like a 60-40, actually.
but there's nothing to compel the agency to make the agency actually change the allocation.
It no longer comports with the best available scientific information, FES.
But that's typically the case in these fishery management regulations. An action is taken, years go by, new information is learned. That could be cause to grounds, rational bases for amending the regulations. But it's not like the service is constantly under an obligation to update all of its regulations every time it gets one new piece of information. This is an iterative process that's taken over time. National Standard 4 says explicitly that if it becomes necessary to make an allocation, then these requirements apply. National Standard 4 does not compel the agency to change an allocation.
Well,
so
that's necessary in light of, I'm sorry, I'm just misunderstanding. If it is necessary in light of FES, so then they couldn't just recapitulate alternative 1. Or do
let me
so by embracing alternative 2, because it doesn't fit with the historical record that they've been relying on all this time.
That would have been a choice based upon a different rationale. I think if the agency had selected alternative 2, they would have justified it by saying, we think that the prior allocation should continue going forward, even despite the new information that maybe because to address the bycatch issue, right? There were other reasons that could have motivated the agency to support alternative 2, even though new information showed that what was done in 2005 was no longer accurate.
And undermines the very methodological premise of that. So they would just have to say status quo ante. That's our new rationale.
Right, but Amendment 30B used an allocation formula, right? Looking at the years 1986 through 2005, right? That formula could have been changed. There's nothing that holds the agency to using the same formula in the past.
But then they wouldn't have come up with alternative 1. They wouldn't have come up with sticking with the same. They would have come up with something different.
Right. So I think alternative 2, sorry, I can make one point. I think the point of alternative 2 was merely to not do an allocation change and merely to update the management system and the catch limits to be consistent with the new FES units. So in other words, Amendment 53 didn't have to do these two things together that it did. There could have been different amendments to accomplish these two objectives. So one amendment could have been just the allocation change, and another amendment could have been modifying the catch limits accordingly.
Well, let me,
but those were-
excuse me, Judge Phillip, go ahead.
No, you go ahead.
The agency brief, citing to the record, points out why alternative 2 doesn't work, all right? But it also makes another interesting point, and I didn't see a response. And that is, even if you get back before the agency, the 3 alternatives differ, what does it say, by less than 1%? And that is not going to provide you with the remedy that you're seeking. And I didn't see a response in your reply brief other than to say, well, you never know what an agency is going to do on remand. Is that correct?
I'm sorry, I'm not following your question, Judge Rogers. What?
Oh, I'm so tired of hearing that. I'm just reading the brief that was filed in this case. All right?
Excuse me, Your Honor, would you mind pointing me to the page at which you're looking in the agency's brief?
Okay. So if you see on page 47, where the agency talks about these alternatives, do you see that?
Yes, Your Honor.
And what you've told us this morning is not consistent with that, even though that's what the record says. And then it says, forcing on page 48, 4 lines from the bottom, the fisheries service to, I'm quoting, reconsider alternatives 3 to 5 would not redress plaintiff's alleged injury, loss of catch share, because the sector landing allocations in those 3 alternatives, quote, vary by approximately 1%.
Yes, Your Honor. So
And
excuse me.
you don't say in your reply brief that's incorrect.
Well, for starters, Your Honor, we were not requesting to force the agency to reconsider those alternatives. I guess
You want more of a share in
What-
light of this discharge. I mean, that's what this is about. This is not save the planet litigation. This is the commercial sector saying it wants a larger share, that its share has been reduced. And contrary to National Standard 4 and contrary to some other things that you argue.
It is true that the commercial sector share has been reduced, but the
But
other
what I'm
problem.
getting at is, even if you win this case, says the agency, you get back before the agency and the alternatives you're looking at are not going to provide you the relief that you're seeking, namely a greater share.
The relief that we're seeking here, Your Honor, is for the agency to do something about dead discards in the recreational sector, because those are presenting
Even if
conservation.
it reduces the commercial sector further, that's
Well, again,
fine with you on remand. That's not what this case is about, counsel, and you know that.
Well, of course, my clients challenged the allocation change because they lost quota, but that was not the only reason, Your Honor. There are ongoing management problems within the recreational sector that are causing
I'm
conservation.
giving you that alternative argument. And I'm also acknowledging the agency's alternative argument. And where did you respond to that alternative argument?
So the reason we, I guess, did not address this is because that is not the relief that we're seeking. Our clients were clear from the get-go in this process. We were not out to necessarily maintain the prior allocation. What we wanted was an allocation review. So the Gulf Council, who developed the Amendment 53, has an allocation policy. And that policy says, when we receive updated information about landings, like we did under the new FES survey, we should undertake an allocation review.
Counsel, the bottom line here I'm trying to get you to focus on is, normally we don't send things back to the agency for a useless act. You don't tell me in reply, this is not a useless act. You're just saying you want the agency to do something about these discards, and it didn't.
That is correct, Your Honor. That is part of the relief that we're seeking here is that the agency acknowledge the discard issue and actually do something about it, because it's causing problems in the overall fishery. It's reducing.
Required, it's a violation basically of National Standard 4 not to do something about it immediately.
And National Standard 9, Your Honor, which specifically
And 9.
contemplates minimizing bycatch to the extent practical.
So if you went
To
back,
the extent practicable, and the agency has told you why, in its view, this is the practicable way to go. You may disagree with that, I understand, but I'm just wondering where the court is left.
So the agency undertook a 22-page bycatch practicability analysis, but it never grappled with the issue here, which is that as more of the allocation is shifted towards the recreational sector, there is more dead discards that need to be dealt with. And
I
so
know, counsel, so the agency said we have 9 alternatives in front of us. Here's our evaluation of them. And for the reasons the agency said, it's fairest to both groups to adopt alternative 3, which leaves the allocation basically where it is.
Right, but there are 2 problems with that, Your Honor. One is that it penalized the commercial sector for dead discards that are happening in the recreational sector. But more importantly,
But the agency explained why the alternatives weren't any better in its view.
Right, but more importantly, Your Honor, the action that it took, the reduction in the catch limit, did nothing to solve the problem with dead discards.
But
Instead
the
of
agency thought it was addressing, in one sense, a larger problem, namely avoiding the extinction of the species. And they thought this was the way to do it. And that's not to say that what your clients are suggesting may not be good ideas, but did either the standard 4 or 9 require the agency to adopt what you're doing, or was it sufficient for the agency to explain its rationale and rely on its expertise?
So National Standard 9 contemplates that bycatch shall be minimized to the extent practicable.
To the extent practicable, counsel. I mean, that's a word ripe with deferring to agency expertise.
Yes, Your Honor, and we acknowledge that. But what the agency did not do was think about and look at ways that bycatch could actually be minimized and then make a determination about why those things are practicable or not. That's what we're saying the agency should have done here. The agency should have said,
all I'm trying to get you to focus on, counsel, and you don't disagree with this as I can read your briefs. It had 9 alternatives in front of it. It dealt with all 9 and explained why it chose one as opposed to the others. That's what I'm getting. It's not that these things can't come up in the future. It's not that you can't file a petition in the future. But in this rulemaking, here's what was before the agency.
we agree that there were multiple alternatives that were considered, Your Honor. Our problem is that the one that was selected is going to end up having negative consequences for the overall stock in the future.
Well, that's
think the
why
service
I
was
asked
required.
you about the agency's alternative response. And you don't, as you say, you chose not to address it.
Well, our response is that there should be a remand for the agency to comply with National Standard 4 and with National Standard 9.
Just
And
to
what-
clarify, on your remand.
Yeah.
Are you asking the agency to reanalyze these 6 options? Or are you saying there's a flaw in all these options because all they did to address bycatch was lower the overall catch limit? So all of these options are, in your view, legally flawed because they weren't addressing bycatch as required by standard 9, or I guess you would say conservation is required by standard 4. So the agency is going to have to go back not and reanalyze these options, which only changed by 1%, but actually do the hard work, in your view, of figuring it out how to, with this new statistical information, reduce bycatch and promote conservation.
Precisely, Your Honor. That's exactly what we are saying.
I just had one question about your argument that Amendment 53's economic analysis is materially inconsistent with the analysis in Amendment 28. If we were to so conclude, what's the remedy? If that were the only defect we were to find, what would be the remedy?
To vacate and remand to the agency for further action.
Now, why would we vacate, given that if it's a failure of explanation and acknowledgement, we sometimes under Allied Signal don't vacate?
Understood, but that analysis was critical to the justification for Amendment 53. In multiple places in the record, the agency justifies all the bad things that are going to happen as a result of this by saying this is going to result in the greatest net economic benefits to the nation. That conclusion is flawed. There is no basis for the agency to make a conclusion like that. That was the lesson from Amendment 28. And so if you strip that justification away, the amendment crumbles.
So on the rest of your analysis, is it correct to think that you're basically saying it's incumbent on the agency at this juncture, given what it now knows about the relative harmfulness of the recreational sector, to abandon its reliance on the historical allocation as between the two sectors? It just has to do something different now. That was the way it did it before, but now that we know the much bigger role of the recreational sector and its relative draw on the stock, that they just need to start from scratch. Is that your position?
Essentially, Your Honor, and I think that's what we were asking the Gulf Council to do in undertaking an allocation review. Starting from scratch, what do we want this fishery to look like in the future? How are we going to address the bycatch and other issues that need to be addressed so that we can have, this fishery for long-term, maximum utilization and making sure that it's conserved for the long term.
But in doing that, don't they still, under the statute, don't they have to account at least for the new statistical information and shares?
Indeed, Your Honor. And,
right, so they can't take that off the table as part of their analysis or as part of their decision making.
Correct, Your Honor. I mean, presumably the allocation would be based on some data or some other decision criteria that would be used. We think the agency could use the historical landings period, but then it has to take into account all this other information that we've now learned about bycatch and discards and make sure that
with it, either not hew to the historical allocation or hew to the historical allocation and do X, Y, or Z to address bycatch?
We think that is ultimately a choice for the Gulf Council to make as to how to proceed going forward.
So you think they could continue to do the historical, apply those statistics, but if they're going to do it in the face of evidence that there's a real big bycatch problem in one sector, they've got to do something along with that to address the bycatch, which would leave you with the exact same percentage you have now. It just might mean more regulation on the recreational sector. That would be fine for your clients.
Yes, yes. Our concern is
So
with
the fishery would be
addressing.
healthier.
Correct. Our concern is with addressing the impacts of the stock and avoiding dead discards. Yes, Your Honor.
Any other questions? Judge Rogers? All right. Thank you very much, Counsel.
Thank you.
Good morning. May it please the court, Gina for the Fisheries Service. The rule here embodies the service's carefully balanced approach to do two things: First, to account for updated data on the status of red grouper stock after red tide algae blooms by reducing catch limits to support it. And second, to, quote, evenly distribute, end quote, the burdens of reduced limits by restoring historical participation of actual red grouper catch by the commercial and recreational sectors in light of more accurate data about the actual catch amounts. Appellants would prefer a different balance so that they could take more fish to others' detriment from this limited pool, but they identify no legal entitlement to one. The Act provides for the service to perform just as it did here, carefully accounting for scientific data and recommendations and selecting catch limits that comply with the Act's national standards, including its direction to balance prevention of overfishing with achievement of optimum yield, a statutorily defined term that expressly contemplates recreational opportunities. The agency carefully considered each of appellant's objections in the regulatory process and well explained how it had adequately accounted for.
Ms. Mishra, I'm sorry, can you slow down a little bit? It's
Sure.
hard to hear you. It has something also to do with the amplification.
Okay, I apologize. At the end of the day, the challenge rule promotes conservation, minimizes bycatch to the extent practicable, includes proper accountability measures and calibrated catch limits, and is supported by well-reasoned.
What if it looked like? It looked like what happened here is you got new statistical information. And you said, well, we have to reallocate based on that. It's going to have to be 60-40. All your alternatives didn't really vary from that number other than the, of course, status quo, which you couldn't do. So that was sort of the, right, that was going to be off the table before it even started. And so all you did was go, we got to do 60-40. And it's a shame that that's going to result in extraordinary increase in, extraordinary to our knowledge, new information about bycatch and mortal bycatch at a time when the species is already in trouble because of these algae blooms. But we are not, in the amendment's words, we're not proposing to directly reduce bycatch of red grouper in this amendment. We're not addressing it. Instead, we're just going to lower the catch limit. Is your position is that no other analysis, standard 9 says it's fine if all you do to deal with what is now recognized to be a material and significant increase in bycatch that you're now aware of, just didn't know about it before, but now it's in front of you. That standard 9 says it's fine to go, we're not going to deal with bycatch other than we'll just lower the overall catch limit. We're not going to do anything bycatch focused. How is that consistent with standard 9?
So the first point is that standard 9 incorporates the to the extent practicable language, and more broadly in the
Okay, but
structure.
you didn't do, I mean, the amendment says we're not going to deal with bycatch directly. We're just not going to deal with it directly. That's what it says.
I don't think that's the full description of everything that went on with respect to analysis of bycatch. So for example, some of the measures that are being pointed out by the plaintiffs here are measures that are already in effect, for example, and there are plenty of others that they aren't getting into. So for example, there's discussion in the amendment of, for example, there would be season closures if incoming data shows that they're going to be projected to reach or exceed those ACLs.
We'll have to close it if they're exceeding the catch limit. That's not addressing bycatch. That's just the rules of catch limits.
But
that happens regardless.
Right, but the idea being that there are a number of different ways in which to sort of preserve and promote conservation that took account of bycatch and bycatch was assessment.
All you do be reacting to after the fact, too late, a problem.
Right.
Like,
so,
if the problem rears its ugly head, then we'll deal with it. That doesn't seem to be dealing with it.
I don't think that's quite what the agency did here. So the agency here did what was consistent with what I understand to be the case law. So for example, there are cases, for example, in other circuits like Little Bay Lobster is one in the First Circuit that talks about how you analyze the proposed alternatives, the things that are before you, and you look at those with respect to making that decision. And then that decision is assessed under the Act and under the Administrative Procedure Act.
So let me be clear, how do you choose the alternatives that, quote, are before you, before the agency, close quote?
So the agency designed the alternatives 2 through 6 to have the same risk of overfishing, basically to prevent overfishing to the same degree. And they designed those to have those kinds of trade-offs and to take fully into account things like the bycatch and the dead discards issue to the extent that there is one.
And we know that because
We know that
give me
because
a record site.
I believe that Joint Appendix 5819 may have this discussion.
5819.
Let me double check that. Where it talked about how I believe it talks about how the acceptable biological catch, which is set to the same as the total annual catch limit, was accounted for bycatch and any increases from the recreational sector. And I think that's something that Judge Millett was actually referring to. They took into account when they were setting these different alternatives that there may be trade-offs about what may happen with respect to discards. And to be clear—
Of course, so let me just ask you, counsel, does the record actually say took into account, I can't recall exactly what you said, but took into account all the new information about discard?
I believe so. Yep. It talks about,
Which volume are you in? Because there's so many volumes here.
I think it's 9. Let me hold on.
But this is 5819.
That's not in the amendment itself, or is it?
No, that's in the final rule.
Final rule.
Yeah.
Sorry. Okay.
And it talks about how
In other words, I didn't mean to slow you up here, but
no, I apologize. There's
this
a
is
number
the
of different—
whole thrust of
right. So
the key argument here this morning.
right.
So
So there's
if in fact the agency has already done its work on this bypass increase information, it seems to me we ought to have those record citations.
Sure. So the first point is that to the extent that they are just suggesting that there was some change with respect to the bycatch issue, that's something that is incorrect as described.
No. But
in the
Judge
rule.
Millett's questions made it clear that, that's not what happened here. All right. The agency learned a lot of things about what had been going on. All right. So my point is, having this new information, I thought what you were responding to Judge Millett was, and the agency dealt with all this information about increased bypass and mortalities.
So the agency discussed, so for example, there's extensive discussion also in Amendment 53 in the entire bycatch appendix to Amendment 53, which there's an entire bycatch appendix that talks about, for example—
And which appendix is that?
That's Appendix B. That's Appendix B. And that is,
Appendix
B as in boy.
1, 2, 3, 4, 5, 6, 7, 8.
B as in boy, and that's Joint Appendix 3515 to 3537. And there's extensive discussion in there. Appellants had conceded, for example, below that the service admittedly undertakes efforts to estimate dead discards. That was something that they had acknowledged. There's also the fact that most of the measures that they're pointing to largely are, first of all, kind of new in being presented in this way on appeal. But in addition, the measures are already in play.
Where, I guess they talked about the bycatch problem. They wrung their hands about the bycatch problem. Where did they consider another alternative for dealing with the bycatch problem other than lowering the catch limit with this wooden 60-40 division?
So as mentioned, the entire way that this challenge has been brought, and in terms of what the plaintiffs have brought, they have not been proffering additional alternatives, for example.
Question, because about whether the agency grappled with its obligations to deal expressly and specifically, it was added by Congress, deal with bycatch to the extent practicable, which means there should be an agency decision or language somewhere that says it is impracticable for us to do anything other than divide this 60-40, because that's what the statistics say, and lower the catch limit.
But I
Where does
guess,
it say it's impracticable to do anything else?
I guess what I'm saying is that with respect to the alternatives that were presented here, the agency fully considered them and its reasoning for why it was trying to restore what was actual historic participation.
No, that's not
No, we
answering.
heard that, but we want to
You
see
want the
where.
specific sites for the bycatch consideration, for example, right?
Sorry?
You want the specific citations
But I
for
would
the
like-
consideration of bycatch.
That's right.
Let's do this in stages. So did any of those alternatives, 2 through 6, deal with the bycatch problem any differently between themselves, other than, the catch limit change? Is there
So-
any alternative approach other than lowering the catch limit that was applied in any of those alternatives?
So there was discussion also of existing measures, which are largely overlapping with the ones that, that plaintiffs have been pointing out today. For example, the Descend Act applies to the recreational sector, and it requires them, for example, to carry certain types of equipment to try to restore discards to the sea if they can. And there are size limits and there are bag limits, and there was discussion of that. There were discussion of season closures. There was discussion of future season reductions, if there would be overages in other years. And it talked about all of those as addressing the bycatch issue. With respect to what was being done here, the alternatives that the commercial plaintiffs have been advocating for.
No, that's not my question. I'm sorry if I'm not being clear. I guess they talked about a lot of things.
Right, but
We have, let's just say there's 6 alternatives, but we can take status quo off the list. Do any of them, do they all deal with bycatch the same way? Yes or no?
I believe that they all take into account bycatch in determining what the annual catch limits will
The
be.
only way they deal with, so there were no alternatives here on dealing with bycatch. Every one of these alternatives did the exact same thing. They dealt with bycatch by doing one thing and one thing only, and that was lowering the catch limit.
There's
Correct?
never been a
Is that
challenge.
correct?
There's never
Is
been
that
a.
correct?
So
I'm sorry, I really am trying to understand what's going on here.
Yeah, I understand. I think the only alternative, so they are advocating for the
No,
alternatives.
I don't want what they're arguing. I'm really trying to help you understand what the agency decided.
Right.
and-
So the agents, right, the
Sorry,
agency.
one at a time.
Right.
That's okay.
Okay.
It'll help if I'm able, if I'm not.
Yeah, I'm
understanding,
having
please
some
let me
echo.
know.
I apologize.
Are you having trouble hearing, you said?
Yeah, just a little echo, so I apologize.
Oh, I'm sorry. Okay, I'll try to go. And if you can't hear it, let me know and then I'll try again.
Sure.
It's really unfair to you if you can't hear it. So my understanding from what you said and from the record is that the only tool for dealing with bycatch that all the alternatives did was the same tool. There were no alternatives for dealing with bycatch. They all just said, we're just going to lower the overall catch. I'm not saying whether that's good or bad. I'm just saying there were no alternatives considered for dealing with bycatch. It was just lowering. There was no alternative 8 that said, actually, we could lower the catch limit, but not so much, but also impose X, Y, or Z on the recreational factor, right? It was all just lower the catch.
All the alternatives also included, for example, reference in the rule to, for example, season closures if the incoming data would indicate that they're going to reach or exceed those annual catch limits. While it is true that these annual catch limits were set taking account of what would happen with respect to bycatch, and that the recreational sector, it was well understood before and after that there would be potentially bycatch, and even the statute comprehends that, for example, in section 1801B3.
Understand. So the answer is, just to make clear,
Right.
that of the alternatives analyzed, none of them did anything to deal with bycatch other than they were going to lower the annual catch limit. And of course, if that catch limit is being exceeded,
None of them
we'll have to
differed on that basis
Right.
because the season closures and the incoming data, for example, is something that applied to all of them. But that is not an issue with it because they did not propose, for example, an alternative or say there should have been some other alternative in the
The
data.
question is,
Sure.
because this is an obligation on the agency to decrease bycatch, especially bycatch mortality, to the extent practicable. So now we've got that they said all we can do is lower the catch limit. And then if something goes wrong, we'll shut things down. Where did they say there was nothing more practicably that could be done? There's all this talking about things. Where did they say, and they should have said that that's the legal standard.
I want to explain why to the extent practicable imports that. And the reason that it imports that
To the extent practical.
imports
what?
this analysis of taking account of, for example, competing objectives under the national standards, which is something that appellants conceded before the district court, and that other
They should have
circuits
said-
like the first.
They should have said, and if they, it's not a magic words thing. If there's a sentence where they said this is all that can be done.
I don't
Practicably can be done. It's not all that could be done, of course, but all that practicably could be done as required by standard 9. They make that judgment.
My understanding is that to the extent practicable, as understood by case law, for example, in the First Circuit, there's a case called Lovegren, and Lovegren talks about how that takes into account the balancing that the agency must do with respect to other objectives. Because when you look at the structure of the act and you see the various different national standards, you see that there are in effect trade-offs between a number of different ones. For example, taking account of scientific data and on the historic participation.
But just balancing itself, just going, okay, here's a bunch of factors in the mix. Let's balance them. Isn't sufficient under standard 9 unless they've said, this is the best we can do as to bycatch, given these other competing considerations.
I think
and I'm
that-
not sure they said we're doing the best
I
we
think
can
that
for bycatch. They said we're not addressing it.
Yeah, I think that understanding of the to the extent practicable and what it demands in this context is at odds with the First Circuit's understanding in Lovegren. I think it's at odds with the concession the
What about
appellants made for the district court.
You have to do conservation first. Whenever you're doing your balancing, you have to do conservation first, and then these other economic and social factors come in second.
And the agency did that here because all of the alternatives, other than the, first leave it as what Amendment 30B had or whatever in their sense, the status quo would be, all of those alternatives were designed to have the same chance of preventing overfishing or having of overfishing.
They don't do anything.
And that's
different.
the standard in
Didn't do anything different. It's like it's baked in that we're not going to do anything other than lower the fishing limit, the catch limit. That's all we're going to do. That's baked into your options because there's nothing else there. When I look at this table, there's nothing else there.
To be clear, I think that the understanding that they were required in this amendment, where it wasn't proffered as an alternative, that there should be particularly considering.
So they don't have to comply with a statutory standard.
It's at odds with the statute.
If a party comes to the agency and tells them how to do it, you're the expert agency, but you don't have to do anything unless it's fed to you by a
No,
party.
counsel, finish your statement, please.
Yeah, I like to make 2 points on that. The first is that the statute itself, as I mentioned, and I believe it's 1801B3, talks about, for example, the recreational sector and trying to promote commercial and recreational fishing, and even makes express reference to, for example, catch and release programs. So there is some sense in which the statute comprehends that there could be there could be bycatch, it could be part of what happens with recreational. Nevertheless, there are a number of provisions in the statute that talk about how conservation takes account, in a sense, to some degree, of impacts on the recreational sector. So for example, there's reference to recreational benefits, and that's in in the definition of conservation and management. There's in 18025, there's reference to it in the National Standard 1, which a lot of cases have said, for example, in other circuits, that this is the bedrock principle and that this is something that gets balanced into the mix.
Conservation that's used in our daily decision included all those economic and social factors that the daily decision said comes second after conservation.
Even if it were true that the daily decision was only talking about preventing overfishing, as I mentioned.
I'm asking you, what is your position? If I read daily, and tell me if you read it differently, it says conservation first. That's what this was about. Your government may like it or disagree or agree with it. I don't care. I'm bound by it. Conservation first, and then economic and social factors.
But
what I'm hearing, I'm just going to lay it out and then you can tell me.
Yeah, I apologize.
What I'm hearing, what it sounds like is you're saying, well, what conservation means is all of these other economic and other factors first place. So daily was kind of silly when it said conservation was something that you would promote in its own right, apart from the economic and social factors. In fact, conservation means balance everything together.
No, so what I'm saying is that when you look at NRDC v. Daly, there's a discussion, for example, of the central principle, and it talks about the principle of national standard one essentially as being the most central, which is this balancing of preventing overfishing while achieving optimum yield, which the statute expressly defines in a way that comprehends these sort of recreational opportunities. And as I mentioned, the statute comprehends that there may in some instances be bycatch. And the very fact that there's discussion of whether it should be minimized is taking account of the fact that there may be some of it, and it says to the extent practicable. What I'm saying is that the case law, consistent with Daly in other circuits, talks about, consistent with the concession of the plaintiffs in the district court, that this to the extent practicable language brings in this sort of balancing to some degree with respect to the competing objectives of the other national standards. And that of course has to be the case to reconcile.
How is it standard? Maybe this is what I'm not understanding. You already have conservation and all this balancing going on under standard 4, right? That's how you get to optimum yield. That's a lot of balancing a whole bunch of factors, correct?
Under the act at writ large, there are many.
But even under optimum yield, I mean, you make the statutory definition, it's a lot of different factors in there, correct?
Correct, in one, for
And
example.
what does standard 9 add? Because Congress specifically added it later to deal expressly with bycatch. So what does standard 9 require you to change from what you would have done previously under standard 4 in determining optimum yield?
Right. It does suggest that there should be some analysis, for example, with respect to bycatch, and that there should be taking account of that as the agency does, consistent with all of the different national standards.
Right? It wants some action, right?
Well, it says
So,
minimize to
counsel,
the extent practicable, which
I need to be clear though. What I understand you to be saying is that the way the statute has been interpreted by the agency, it's not necessary to have an independent alternative focusing solely on conservation, but rather it's sufficient if, in reviewing the other factors or standards, national standard, conservation is considered. And I thought your answer was, in effect, if we read the entire record, we will see that when the agency was considering what to do here, as to each of these national standards, and as to each of the alternatives, we will see that the agency said something about how one standard would promote conservation either better or worse than another. And what I thought Judge Millett was asking for was, not in these words, but where would we find that? Or where would we find a statement that says, we've considered all the other conservation alternatives and determined they are not practicable, and maybe given us a reason or two as to why they're not practicable. And I haven't heard you give us that answer, and maybe it's not there because that's not the way the agency is looking at this case. But that is at least what counsel has presented in this court as part, or really as his main argument on behalf of his clients.
Right. So I wanted to say two things. The first is that the agency absolutely did clearly take account of conservation, even in the narrow sense understood by the plaintiffs, when it set all these alternatives to have an equal chance of preventing overfishing, and it took that into account. Now, it did so in a balanced way by taking account, for example, the intertwined nature of the catch limits and the just realistic fact in the world.
And we hear you saying this. Where can we find that the agency said that?
Sure. So the agency talked about how it was taking into account optimum yield with respect to recreational opportunities at page 5818 of the joint appendix, for example. There's discussion of the to the extent practicable language and the discretion. This is not necessarily specific to the agency's interpretation, but it's actually, as I mentioned, something that is consistent with the understanding of the First Circuit and talking about how there are these trade-offs between the national standards and the concession of the plaintiffs in the district court, that it does bring in the to the extent practical language does bring in this taking account of the competing objectives. And for example, the updating of the data, updating to reflect the more accurate data here was, in fact, reflective of also National Standard 2, talking about scientific information and how to take account of that. There was consideration of how this would impact the recreational sector and all those statutory provisions, as I mentioned, and some of those, as I mentioned, were referenced by the agency as well. So there's both case law and there is the agency's understanding as described here, but there's also the concession, as I mentioned, in the district court. Here, I would say at the end of the day, the understanding of NRDC v. Daly was satisfied by the agencies constructing those alternatives carefully to make sure that they would equally prevent overfishing, even under the understanding being proffered of the statute by appellants. So with respect to bycatch, I also want to point out that, as I mentioned, there was an entire assessment of bycatch in Appendix B. There's a whole bunch of other citations in which they talked about all the many ways in which bycatch is being addressed and minimized, including not just the reduction of limits and taking account of it. As I mentioned, that's at Joint Appendix 5819.
Existing things or new things imposed here?
So the taking account of it in the limits was certainly, how they constructed these
It's a
alternatives.
fact question here. The things that they discussed there, catch limits and season limitations and stuff, those are all things that were already in place. And the high amount of discard and discard mortality that the record revealed, particularly once you saw the increase in the recreational sector, already reflected the effects of those efforts to diminish bycatch, correct? Those things were already in place, and yet we have the discovery, guess it was going all along, but it's new information to the agency, that there is, wow, our bycatch problem is much bigger than we thought. Mortality is much worse than we thought because recreational fishing is much bigger than we thought. And that was already with all those things that were discussed in place, correct?
So the Descent Act was in
anything new there?
2020. I think the idea is that many of the particular measures they are now identifying for the first time, quite frankly, some of them at oral argument on appeal.
I'm not talking about the bariatric chamber thing. Okay, what I'm talking about is the things that are discussed by the agency. You talk in the appendix. I mean, they talk about the bycatch problem and wring their hands a lot. There's no doubt about that. Is there anything that they mentioned there that you say is part of the calculus here as controlling bycatch that was not already in operation at the time these large bycatch things were reported? As in, this bycatch happens even with those things in place. Is that true?
Well, equally under what they have pointed out as measures, those.
No, that's not my question to you. My question to you is, are the measures that the agency mentioned things that were already in place, and yet the recreational bycatch and mortality are as high as they are? But yes or no?
Some of them interact differently. So for example, as I mentioned, the season closures for taking account of incoming data under the new survey, which is part of adapting to the new data and the new methodology of it, is something that operates differently with respect to taking account of what this amendment does and how it's taking account of the methodology. So
sorry, I am not understanding the answer. Is there anything new in what they discussed?
Yeah, so
things that could control mortality bypass that were not already in place. We'll put aside that little bariatric chamber thing.
Right, which actually applies either way. So there are those protections are there as well.
That's a new thing. So did that statute post-date the agency decision?
It's 2020. I don't think so, but my point is actually that it applies to the recreational sector, so they get the whatever concerns there are about it.
But anyhow, so there's.
Right. But I guess what I'm saying is that some of the things like season closures based on incoming data under the new survey methodology do actually interact differently based on this updating with respect to the data. It's taking account of the new type of data, the data that is more
They didn't
accurate.
take account of it. They didn't change. Did they change the season?
They calculated what the season might be, and one of the considerations that they made was that there could be actually some alternate problems from alternative 2, for example, with respect to aligning the season with other seasons. So for example, you could end up with bycatch issues that are created or worsened by needing to throw back because allocating less, as the commercial sector wants, allocating less overall ACL to the recreational sector means that they have to stop fishing potentially
Oh,
earlier.
That's just a pre-existing problem. But that's always been, the pros and cons of these limitations that were all in place. And so the only limitations discussed are ones that have done nothing to address the problem that is now, it was going all along, but the agency didn't know about it. Now it knows about it, and now it knows about it. And it says, well, we still feel like we have to do the 40-60 thing. Think we must do that. And so where are we saying, but given that we now know there's so much more mortal bycatch than we thought before, are we doing anything different other than lowering the catch limit?
I think that, as I mentioned, there are some things that are different in terms of taking account. There is some things that are different in terms of how season closures interact.
The statute isn't about taking account.
And there's
It's
also
about doing something.
There's also a prejudice requirement with respect to this here. So looking at the alternatives as they were before the agency.
Sorry, I'm sorry, there's a prejudice.
There's also a prejudice requirement in terms of how the Magnuson-Stevens Act and the APA comprehend that this analysis at the judicial review stage should go. It should be looking for whether the analysis had something clearly unreasonable and that further analysis would be determinative. And with respect to how the National Standard 9 operates.
Important statutory criteria, just assuming that.
But they did
that
right.
If you show there would be a different outcome, you have to show there'd be a different outcome?
No, that I think it's still that further analysis would be determinative as to the assessment, for example, of the alternatives. But the point here is that if they want to proffer an alternative, as Judge Rogers mentioned, there are other mechanisms for them to try to seek to change the law.
No, we understand that, but I think I just want to be clear in my own mind that with the new data, some of the old tools will work differently. And therefore promote conservation.
I believe that's
is
so.
That your argument, counsel?
That is part of our argument, yes.
What we can find in the record, and you can give us some assistance in that regard by giving us some page numbers, given the voluminous record here.
So as to that issue, here are some record citations, and here is a case citation.
Well,
first,
I might suggest that we have you just submit something in writing so that, for instance, I don't write down the page numbers and transpose the numbers or something like that. So we
if it's all
have
right,
the correct numbers and we have the case citations other than those that are already in your brief.
there's also Gutierrez in the DC Circuit, which talks about taking account of incoming data, which is what I'm describing.
Did you hear what I suggested? Do you have any objection to that?
I think that it may not be necessary here, but we would, of course, be happy to do whatever the court orders. I can list them here and they would be on the recording if the court would like. But
right, and if it's on the recording, then I have to go get the recording and transcribe it. That's all I'm getting. You've got this data probably on your computer.
I have it before me, the particular page sites, if you'd like them, but I don't, I'm happy to provide them later.
If you read me your best language.
Okay.
This site and then read me the best language, but I think Judge Rogers has requested that there be follow-up letter, if I'm understanding you correctly, Judge Rogers, with.
I think counsel doesn't want to do that, Judge Millett, and I'm certainly not going to force her to do it.
Okay.
No, I'd be, of course, happy to do whatever the court would like me to do. I just have.
Why don't you answer Judge Millett's question now?
Sure. So in the Amendment 53, the citations, just so you have the numbers, are Joint Appendix 3323, Joint Appendix. Yep, I'll say it louder. Joint Appendix 3323, Joint Appendix
Wait,
3523.
can we do one at a time? Get there with you. Okay, so 3323. And the language there,
What, if you would like to start the final rule, actually, I think it would probably be the best. That's at Joint Appendix 5814.
no, see, we're not doing 3323, we're doing 5814?
Yep, and I can come back to.
Hang on a second.
It's in the rule as well.
All right. See, I don't. All right, I gotta get a new volume. Which volume is? 58. Okay. You know which volume that is?
Which part of the federal rule?
It's either 9 or 16. Joint Appendix 5814, it's page 25573 in the volume 87 of the Federal Register.
I have it right before me. It's the front page of it that you're
Yes.
referring to?
Wait, sorry, are we talking about the rule or are you talking about the federal?
The rule release. The rule release.
87 Federal Register, what page number?
25573. Top of the right column on the Federal Register notice talks about the in-season closures. And then the amendment citations I will provide you talk about that, taking into account, as I understand it, the incoming data, which would be from the new survey methodology.
Right, so this one just says, are you talking about recreational red grouper harvest is managed with catch limits in season, which is what you used here was catch limits, in season and post-season accountability measures, season and area closures, a minimum size limit and a recreational bag limit. That's what the language you want us to look at?
No, the
That's
last
like a
part,
general description of
the
it.
last part describing season closure here talks about how there are season closures when it's projected to reach the recreational annual catch limit. There were careful scientific projections made at this stage based on the updated survey data. And that's what was taken account of in terms of setting these alternatives, et cetera, to set the equal prevention of overfishing percentages, which satisfies daily.
There's just enforce the catch limit. They're not independent. They just enforce the catch limit. Is that what you're saying?
Well, they take account of the data about how close they're getting to the catch limit, which were set taking account of this.
It's the measure all they do is enforce the catch limit. So we're back to where we started, which is the catch limit is the only, and this might be right or wrong, but that the catch limit is the only thing the agency has done to deal with bycatch.
Well, when the
The fact that
agency,
this enforces the catch limit doesn't change anything.
when the agency gets new incoming data showing they're reaching or exceeding the catch limit, it talks about, for example, future season reductions if there are overages in prior years, and it takes account of that.
They will
to
enforce
adapt
the catch
that.
limit if it's wrong.
They will, but that will also address to the extent that it also addresses that discards were taken into account, as I mentioned, in the catch limits. And so taking account of that new data will interact differently with the new updating to take account of the new data and survey methodology. Putting that aside, as I mentioned,
Computing compliance with catch differently, or you're just saying we have new numbers. And if we get new numbers, because there is an awful lot of bycatch mortality here, that maybe they'll hit the catch limit sooner than we thought, at which point we'll have to close it down.
the only premise for the challenge here that's before the court today,
Is what I said accurate?
my understanding is that the assessment under the law here, the case law and the statutory language,
Is my understanding of what the agency said here. I'm not looking for case citations. Is it accurate that what you've said here, this was your key language, is that, and you can submit more, but this is where you pointed me
Yeah.
to start, is that they will, of course, they've got new statistics, so they're going to get new information in about compliance, and hopefully their new methods will get better and better for getting accurate data. And if it shows the catch limit is being exceeded, we will respond to that, correct?
or that if they're reaching it faster.
Right, we will respond to that. So that's not a measure they've done now, that's simply catch limits are how we're dealing with bycatch. And if it turns out the catch limit is approaching, or we turn out it's been exceeded, we'll have to react.
I agree with but I will point out again that the statute expressly comprehends that not every amendment is supposed to address in all ways bycatch, that their trade-offs are comprehended expressly in the statutory language
I know.
and in
I've
other
asked time and
decisions
again
by other
where
courts, as well as daily in this
technical is.
court.
We don't have that.
to the extent practical. What I'm trying to explain is that the case law does not require that type of analysis. It requires taking account of the bycatch, trying to do things that take account of it and address it. And the agency did do that by making sure that its alternatives took account of what those effects would be. The statute expressly comprehends there may be bycatch. The agency expressly comprehended the trade-offs, for example, of giving less to the recreational sector and how that could actually cause more throwback problems because the season would close earlier and people would be out there fishing for other fish and have to throw more back. It had extensive discussion of all these
That would
different
cause,
things.
if they shortened the season, it would cause more mortal bycatch than the longer season where people are, everyone who, because you're only getting the accidental throwbacks, I assume, if you're out of season. And so that's going to be more than the bycatch problem that's caused by, like, for example, say your season closes normally in December. And so we've got whatever your statistic is on mortal bycatch going all the way to December. And we know these are pretty high numbers. And you're saying if we have to stop the season in November, the number of people who accidentally catch red grouper and throw them back will be higher, more mortal bycatch than if we had the season open and people were intentionally catching red grouper and throwing them back. That's what the agency found?
It found that there is an offsetting effect. I'm not saying that they found that this would necessarily translate to more in the other direction, but what I am saying is that the agency did a careful trade-off that involved its scientific expertise.
No,
where it
you
took
said,
account.
you said if we shorten the season, there'll still be discards. I thought you said there would be more of a problem, but there'll still be a problem, but there'll be less of a problem because there's less throwback from accidents.
There is another countervailing effect is what I'm saying, that it took account of when it was trying to assess in the process of trying to minimize bycatch to the extent practicable. And when it did the assessment of what was practicable, it took account appropriately, as the appellants have conceded, as case law, for example, in other circuits establishes, it took account of the trade-offs with the other competing objectives, for example, under the national standards. And to reconcile those standards in the act, there needs to be an understanding that some of them have to give way to one another to some degree. So it can't be obviously that.
I understand your argument. They balanced all these other things. I've just been asking for where they address bycatch. And it sounds like we just keep ending up with.
There was extensive
everything.
addressing. I think to the extent that they needed to develop a separate alternative, that's not what the case law requires.
Did you want to ask about the study?
I had a question about the economic analysis.
Sure.
I read the briefs on both sides, and I read the economic analysis in Amendment 28 and in this Amendment 53, and I honestly don't see the difference. In Amendment 28, the service said it was not possible to rank the alternatives based on the expected net benefits to the nation. And they had, in that case, I think 9 different alternatives. Here they have 6. And the point that was made there was that the recreational sector's quota isn't efficiently allocated within the sector. You don't know, there's so much variation of revealed preferences among recreational fishers that you just can't necessarily know the optimal marginal fish value. Anyway, the analysis in support of Amendment 28, which the service said did not allow the benefit to the nation to be relied on, seems to me identical in nature to the analysis relied on in Amendment 53. And I would love your response to what I'm missing.
Sure. So I would say 2 things to that. The first is that it wasn't a change in position in that formal sense in terms of what would be have bearing on this amendment that is under consideration now in this challenge, because it was talking about, first of all, the alternatives in that amendment, and it specifically said ranking of the alternatives in this amendment based on the expected net benefits.
So this is like the old joke with the facts of that case are different from the facts of this.
Well,
case.
what I would
mean,
say is that,
Fairly speaking, and I
Right.
drilled down and I did not see a.
right, so as I understand it, this was a data-specific analysis, right? So in terms of what data was available, and I understand your point as to what underlying principle was being discussed. To the extent that there was any inaccuracy, though, whatever this was, even if it were a change in position, it was fully explained. And so the discussion in the rule talks about how primarily what Amendment 28 was really talking about was this maximization versus comparison of specifically identified alternatives here.
No, they were comparing a set of alternatives and they were assessing them. And the service said, we can't add the economic benefit to the commercial sector and the economic benefit to the recreational sector because those two things are incommensurable measurements for this reason. I'm not sure I agree with it, but that is not my job.
Sure.
So they do make a point in support of 28, and it's the effort to distinguish it actually that to me is problematic, because if you said, yeah, we did that there, we thought that was like, the whole thing is average and across the recreational sector, who cares whether the particular marginal fisher has a lower
I believe it was cited there. It is, but it was the reference that was being made, the argument that's being made in terms of what was being asked about
I
by
heard you
Judge
mention the
Rogers.
First Circuit case. Tell me, I don't see it cited in the briefing.
So it is Little Bay Lobster. I can give you the citation if you'd like it.
Please.
Yes,
352 F3rd 462 at pages 469 to
hold on,
470.
352, Fed second,
Third,
Fed third,
462,
462,
pages 469 to 470, which is relied on in a Fifth Circuit case, Coastal Conservation Association, 846 F3rd 99,
846, Fed third, 99.
at page 108, that talk about how the agency's analysis needs to be sustained unless it's clearly unreasonable as to a particular omission for which further analysis is likely to be determinative. I made reference to this before. The prejudice argument was made in the brief. That was the colloquy that was being had, for example, about the alternatives 3 through 5 and how, a remand essentially wouldn't make much difference. These were very close and there's not much reason to expect that things would be different. And I guess what I would say is that to the extent that there was concern about Amendment 28 and Amendment 53, all that's happening is that Amendment 53 made clear that it was taking the position that on this data, it believed that there was sufficient evidence to make a determination as to these particular alternatives. And that question, that determination is not undercut here. It's not clearly unreasonable. It's also the case that remanding wouldn't necessarily be determinative of any of the agency's decision or selection among the alternatives, because as mentioned, it's not clear that it would go any other way based on just whether Amendment 28 had some language that may or may not be consistent with the better understanding now with respect to 50.
You back up, you said you had two reasons. One, in Amendment 28, it was not a broad statement of principle, but data specific. And your second argument was?
There is explanation affirmatively in Amendment 53 that here there was a determination that there was sufficient data to make that comparison, the relative comparison.
There's no difference in the nature of the data on the preferences within the recreational sector in the two different records that I
And-
can perceive.
And if the assessment of the court were that there was some change in understanding, it undercuts primarily Amendment 28, not Amendment 53, where there was extensive discussion of why it was well-founded here.
So
To the
you're saying
extent
it
there's
would
a
be harmless
concern,
error if they had made this error.
right,
How can we
because
know
with
that?
respect to the particular alternatives here, there's not any reason to think that between 3 through 5, that it was going to make much difference to the analysis. And I would also say that with respect to the alternatives that the commercial sector is proffering, none of those would have actually done the things that the agency rightly was taking account of, which were not clearly unreasonable, such as updating for the actual historic participation. The 76-24 proportions or percentages that the commercial sector wants are based on an amendment that was based on data that they admit was not the truest state of the world representative, right? And so that there's updated data now that shows that the foundation for those numbers, the alternatives they want is really not there.
If the service were to depart from relying on historical allocation and mirroring that and carrying it forward, what in other fisheries and other species, what are the other ways that these allocations are made or might be made here?
You mean as opposed to taking account of historic?
Methodologically.
Right. So historic participation reflects some sense of relative interest in participating in the fishery by these different sectors, recreational, including, kids out fishing with their grandparents, and the benefits that accrue to them that are not just about how many fish are caught, kept, killed, and sold, as in the case of what happens for the commercial sector. There's many other considerations described under the national standards that the agency did take account of
No,
in
I'm
doing
asking
its
more
analysis.
broadly, and maybe what the sector's relative shares were. Is that, how prevalent is that?
I'm not sure. I don't think it's in every case. However, what I would say is for purposes of this case, the commercial challenge here, it's saying this determination by the agency is unreasonable, which is of course the standard, is based on only alternatives among which they're all based on some sense of historical allocation.
I know
It's
that,
just that the ones
yes.
they're basing it on are based on outdated or less accurate
Yeah.
data.
Partly I'm asking you because it seems like the gist of their position is once it was revealed to the service that in practice, historically, the recreational sector actually occupied a much bigger share of the fishery, drew on a much bigger share. It was incumbent on the service, I think they're not saying this explicitly, but implicitly, to abandon that.
Right. I think that they're trying to make an affirmative values-based argument that the service should take into account. And at that point, I would say that would be them trying to substitute their judgment about what matters in a way that is at intention with some of the material in the statute that I was pointing out. So for example, the statute does talk about recreational benefits that it doesn't just adhere in the most
But
fish
not
caught
at
and
all
kept.
costs, and that's the difficulty. Not at all costs.
Of course, with these trade-offs and
The other
taking
question I
account of
had
it.
is about permits, like the Louisiana brief says, recreational fishing is recreational fishing. Of course, it's not as regularized and regulated in the same way as commercial, but many states require recreational fishing permits. It seems like now with apps, it seems like there's so much one could do to track bycatch, for example.
And in an appropriate challenge or an appropriate petition or an appropriate avenue, many affirmative policy-based considerations would be taken into account. Here, there was an extensive analysis taking into account the effects on the ground of what these different alternatives might be, taking into account what the impact would be of better reflecting the historic participation, deciding to, taking account of the national standards, more evenly distribute reductions across the sectors based on their reflected interest in participating. And to the extent that there is some desire affirmatively to make change as a policy matter in this area, as the Descend Act or some of these other statutes and other regulations show, there are avenues that may be pursued. And so if the commercial plaintiffs here are really concerned about those underlying things, then there are other ways in which they can do that. But this amendment did promote conservation. For example, it did reduce everyone's annual catch limits to take account of impact on the stock in the stock assessment. And in reflecting historic participation, it was reflecting some of the benefits that the statute comprehends.
You effectively made that argument. I just had a really simple descriptive question about the math. On JA 3427, the appendix says that 1.73 million pounds in effort units is equal to 0.824 million pounds in the phone survey units. And then when they do that it's functionally the same allocation as is translated as in Amendment 52, but the numbers come out somewhat differently in the record, and I'm not sure why. 75.4% versus 24.6 allocation, not 76 to 24. Why are there different numbers there? Do you know what I'm talking about?
I'm looking at 3427. Is that the one you said?
And it's also 3342. There's just one set of pair of numbers is 75.4 versus 24.6, and the other, which is Amendment 30B, is 7624. Why is it not 7624 in the recalculation for the alternative in this rulemaking?
I'm looking at 3427. Is that where you're saying? And 3372, is that where you're referring to?
If this is not familiar to you, well, I can skip
Well,
that.
it's 3342.
3342, I'm sorry.
Yep, 3342, 3427. Just the question is why Amendment 30B talked about 7624, but the recreation of that in the current chart that you have pointed to has some decimals, and maybe it's just a rounding decision.
You know, I'm not sure, Your Honor, because I don't know that I see the references.
Well, we could always submit a letter to the agency.
Sure, I don't know that I see those numbers at these pages.
We've been here a long time. I'm going to let you
All right, thank you.
wrap up.
Any other questions? All right, thank you very much, Council.
Thank you so much.
Your Hobbs, we'll give you 3 minutes.
Thank you, Your Honor. Just to touch on a couple of brief points here. First of all, with respect to Amendment 30B, the assumption there was that the ratio of discards to landings were roughly the same between the commercial and recreational sectors. The citation for that is Joint Appendix 4558. That was the assumption for 30B when the 7624 allocation was set. That is what fundamentally changed when it came time for Amendment 53. And it was learned that the ratio of discards in the recreational sector was actually much higher. That's why it's our contention that when the agency learned that new information, it was required to do so.
There's argument here and questions about, is your position that once they discovered the new information, call it 7624, and they discovered bycatch problem or they discovered, or they just computed or figured out that with that change to 60/40 is a big increase in bycatch. Is it your position that the agency has to abandon reliance on historical allocations as part of its decision-making and setting the new amendment here?
It's a good question. And to answer your question earlier, that is typically what is done in allocations, that at least that I've been involved with around the country. The starting place is typically, well, what did everybody catch in the past?
Are you asking for them to change that starting point?
We don't think that's necessarily needs to change, but that can be the starting bid. And then you have to look at, okay, if we make an allocation based on this, are we complying with the national standards?
Now, on
Or
National
how can
Standard
we?
9, I just want to understand the scope of your proposed reading there. If the service amends a fishery management plan no matter how focused the reason for it, the service has to consider every reasonable alternative measure that could potentially minimize bycatch?
I don't think the service needs to do that every time, although what.
Okay, so if this rule is all about just hewing to the same historical data, the same historical period of years, taking the new survey data, what it tells them, and mapping it onto that, right? Just doing a translation from, Fahrenheit to centigrade. What is the position? Why would that trigger an requirement to consider every potential measure to minimize bycatch and not be satisfied by what the service did here, which is say, ooh, there's more bycatch going on, has been for years, than we realized. And so we have to lower the ceiling for that.
Right. So the agency, so I think what the statute says is that, conservation and management measures shall minimize bycatch to the extent practicable. I think what the reason that matters here is because the agency learned something new about bycatch that it didn't know before. And so that should have triggered an obligation in the agency to do something about those higher levels of bycatch. In other words, if the agency had just updated the allocation formula with the new landings numbers, not taking into account the bycatch as was done, then the agency is failing to consider an important aspect of the problem here.
So let me ask you, counsel, were these objections raised to the agency? And by that, I mean that it was impermissible for the agency to take the approach it has taken, namely by saying the tools that we've employed in the past to promote conservation, we expect now that there will be different responses. And we'll look at them, we'll look at those responses, and act accordingly then. But for now, we're doing this translation to FEC measurement. And we know a lot more. But in our agency opinion, we're not persuaded, given the trade-offs between these different standards and different interests involved, that we're in a position to do more until we get further information about how things that we have in place function with this new data set. And based on what was presented to us, while the agencies has the burden to support its action, nevertheless, it responded to what was presented and has explained why it's decided to do what it did now. Long question, sorry, but you get the thrust.
Yes, I get the thrust, Your Honor. And our response is that when the agency decided to act here, to enact Amendment 53, make the allocation change on paper, that triggered an obligation to ensure compliance with all of the national standards and the other statutory requirements.
What I'm getting at, counsel, is the agency says, look, we may not, these are my words, not counsel's words, we may not have an alternative that says this is all about conservation, but rather we have these alternatives where they have different effects on conservation. And given the other concerns we have, in addition to the interaction of the standards, why isn't this a reasonable way to proceed now? Given that it has this new information, it's not going to ignore the new information, but it wants to see how sort of the system works. And while it takes this sort of broad brush approach of just lowering the catch, why isn't that enough for now? That's what I'm not clear on. Not that you may not be entitled to consideration of these other options, including what Congress has put on the table. But I'm not clear exactly why what the agency did in explaining what it was doing now and not ignoring Standard 9, even though from the court's perspective, it would have been a lot easier had they included a sentence that says, we've decided that anything else at this time is impracticable.
Yes, Your Honor. I've looked for such a statement in the record. I've not been able to find one, nor is there any commitment from the agency to actually take action to minimize bycatch in the recreational fishery in the future. And
well, we can't assume that the agency is going to act unlawfully, intentionally, if you understand what I'm getting at. There's a presumption here.
Of course, Your Honor, but I would also submit that.
And please tell me where it is. We are making a decision to wait and see and get more information about the bycatch problem because we got new statistics. And so for now, we're just doing the annual catch limit. But as to further bycatch measures, we want to wait and see how these new numbers work. Did they say that?
I have not found any statement like that, Your Honor.
Hey, did they say we want to do a wait and see and deal with this incrementally?
No, my understanding is that they essentially threw up their hands and said, we've done as much as we can do, but they never even made that finding.
What do you mean, counsel? The agency said it's done as much as we can do. Isn't that tantamount?
I'm sorry, Honor. They never made that finding. But if you read the bycatch practicability analysis, it goes through all of the prior measures that were in place. Nothing new was done in this amendment to address bycatch, notwithstanding the new information.
I know, but that's like,
but
the
the
point
agency
is now you have this new data and you can see how these tools work. And they don't know that yet. So they say, okay, so we just reduce across the board for now.
They didn't say that. They already knew these tools didn't work. That's what caused the bycatch problem. They already knew these tools are the ones that left them with the current bycatch problem.
Correct, Your Honor. And importantly, also reducing the catch limit did absolutely nothing to minimize bycatch, right? That accounted for the mortality, but the bycatch just continued.
That's an overstatement, counsel. And you don't have to make it to make your point. But I just think your argument has to be, presumably, if you presented this to the agency as you're presenting it to the court, that the agency couldn't do anything except consider an alternative based on alternative 9, on National Standard 9.
I think as we've talked about, Your Honor, there are a number of things the agency could do. I would even point the court to the agency's own statements in the Oceana case about what Section 1853A15 requires, and that's to accurately assess bycatch during the fishing season. That is not.
In other words, from your client's point of view, it would have been better for the agency not to have done anything. All right? And let the system go forward. And then in the future, and not too necessarily too distant future, consider this new data and the translation and just delay the translation further rather than get it done with, get the new data, chew it over once you see how it works. Now that you have the data, that's just impermissible. And you may be right, but I just want to understand if that's your argument and that's how you presented it to the agency.
Yeah, I think that's a fair assessment, Your Honor. I think what we were saying is that we acknowledge that there's this new survey data that provides a rational basis for regulatory action. But then the result of that, the action that was actually taken, is arbitrary and capricious because it failed to address an important aspect of the problem, and that is the new information that was learned.
What do they need to wait and see for, since all this were numbers that reflected what was already happening out there, including the bycatch problem? So we already know, the agency already knows what the bycatch problem is with these new numbers. They said this isn't something they've invented. They said this is what's been going on all along. So it's been going on all along. It's a 60-40 split. And also what's been going on all along with that 60-40 split is a much more significant bycatch problem and mortality bycatch problem than we realize. There's nothing new to wait and see what happens. They already know what happens with these numbers.
Precisely, Your Honor. I'm not sure what waiting longer and having further years of more bycatch would have told the agency that it didn't know. That's right.
Any other questions? All right. Thank you very much,
Thank you, Your Honor.
counsel. The case is submitted.